All right, welcome back. It's been a little while. Unfortunately, life gets in the way sometimes. And busy over here, so this is the first thing to go, sadly. But that just means that I've got a backlog of things to cover and new things to cover, but not today. But we'll get to that. So yeah, basically the outline for today is I'm going to start with Schofield versus Guillard and go from there. We'll see where I am when I finish that. I might try to get some delete laws, Las Vegas shenanigans, but there's a chance that I'm done after Schofield. And even if I do get to delete laws, I won't get through all of delete laws, but I'm basically going to play it by ear. So I mentioned new content, but not for today. But for that, I do have homework for you. So I'm sure you all remember this gem of a video from Van Balian. Sovereign citizen gets what he deserves when he interferes in a traffic stop. It's from April 7th, and it's the one where the son of a Texas county clerk gets himself arrested for interfering. The county clerk was arrested the next day for interfering, and now the son, the county clerk, and I think even the driver, who wasn't arrested, just ticketed, if I believe, they're all suing the county that the mother is the county clerk for. And that's going to be an absolute train wreck. And that's what I'm here for. So, your homework is I'm not going to react to the video because this old computer will object. So, your job is before I do cover it, hopefully I'll get to it sometime in the next week. Go watch Van Balian's video, especially if you haven't already. It's an interesting one, to say the least. And even if you have watched it, Van deserves another view, so go watch it again. And if by any chance you're not subscribed to him, subscribe. He's great. So that's one part of your homework within the next week. The next part is so I I think in order to help grow my channel, speaking of which, like, share, subscribe, do all that fun stuff. I usually forget to say that until the end. But I think I'm going to explore clipping some shorts out of my long videos. And so if there's an under a minute clip, basically, that you find extra interesting, or I'm overly animated or something, let me know. Basically, leave a comment, say, with a timestamp, of course. Just say, short timestamp this, and I'd appreciate it. We'll see if that does anything to help or not. So with that, that's all the announcements I had. So let's jump. Oh, also, this will go out on the morning of July 1st. So for those of you north of the border, happy Canada Day. It's going to be a fun weekend, north and, well, not south of the border, but south of the Canadian border. But now let's jump to Idaho, awfully close to Canada, and Schofield versus Guillard. So where are we here? Scroll down, scroll down. So last time we were here, we had, let's find it. Okay. So we had on the 6th of June, Professor Schofield submitted her motion to dismiss Guillard's counterclaims. And then we had a lot of nonsense about trying to serve her attorneys as counterclaim defendants, which I mentioned last time why that's inappropriate, and in addition to the attorneys discussing why it's inappropriate in their motion to quash. And then the next day, she tried to execute summonses for the attorneys, and then we left off with the scheduling conference litigation plan, which they did agree to, both parties, and we had the suggested discovery plan from Professor Schofield because they were unable to agree. And so today we have the discovery plan from Ashley Guillard, which will be fun. And then we have what is now labeled as the stricken response to motion 22, motion to dismiss for failure to state a claim. So basically it's Guillard's objection, or objection to the motion to dismiss the counterclaims, but spoiler alert, it was stricken. So even though it's stricken, it's the one I'm going to read for reasons I'll explain in just a second. So next we had a docket entry order from the judge, which, okay, this one's about adding third parties, and we're not going to worry about that yet. But the same day, we had a docket entry order striking 32, the stricken motion I just mentioned. And the judge's order says, the response exceeds the page limits outlined in Local Civil Rule 7.1. Defendant, counterclaimant shall file a complaint response on or before July 6th, 2023. Said response shall not include any arguments not already raised within the original response. Plaintiff's reply in support of the motion is therefore due on or before July 20th, 2023, signed by the magistrate. So basically, most pleadings have page limits, and Ashley Guillard did not comply with those page limits. And so the judge said, no, try again. And frankly, he was, I think, kinder than he would have probably been to most lawyers, because Guillard submitted this on the due date. So I think that's why the judge said, hey, you can't raise any new arguments. You've got to stick with the arguments you already made, since those were made on the due date. Any new arguments would be late, but you've got to condense those to fit the rule. Whereas if I did it, the judge might have taken a black Sharpie and started at the page limit and just crossed through everything else and said, all right, this is the motion. And that wouldn't have been improper. But I think since she's a pro se litigant, he probably did it this way. And so later that same day, we had the refiling of the motion to dismiss, or response to motion to dismiss by Guillard, presumably complying with the page limit. And then today we had Guillard's response to the motions to quash summonses for the lawyers. And I'm not going to do those ones today. I'm going to save it for a future video, just spread out the BS. And then we also have notice of assignment to the magistrate judge and requirement for consent sent to counsel for the attorneys regarding the answer and third-party complaint counterclaim. So you'll remember, well, I mentioned it earlier in reference to the motions to quash. Well, I think the attorneys are not proper parties in this case. They haven't been properly added. And I went over that in the last video. So you see this and you think, now hang on, is the judge telegraphing that, hey, I'm going to overrule the motions to quash, even though the objection only came in today? I don't think so. I think what this is he's basically saying, hey, for me to even rule on this regarding the motions to quash for the attorneys have to agree to let the magistrate judge hear it, as opposed to the federal district court judge. So I don't think this is telegraphing anything. I think it's just the judge saying, hey, well, the magistrate judge saying, hey, I need permission from even the improperly added parties. I need their permission to hear their motions to quash. So I think that's all that's actually telegraphing. So with that, let's jump to Guillard's proposed discovery plan. And most of it is going to be the same, but so I'll skip over most of it, but let's start reading this part. So the parties have been unable to reach an agreement on the discovery plan, partly because attorney Wendy Olson, speaking on behalf of herself, and attorney Caron and Watkins refused to be listed on the documents as counter-defendants and refused to allow discovery topics related to the counter-complaints against them. In her counter-complaint, Ashley Guillard alleged that the attorneys violated Rule 11b of the Federal Rules of Civil Procedure by filing the frivolous claims against her without reasonable inquiries or regard into the truth or falsity of the allegations, and without reasonable inquiry that it didn't violate Rule 11 of the Federal Rules of Civil Procedure. But Rule 11 isn't a cause of action. It's grounds for sanctions of the attorneys or litigants within the litigation. But it's not a cause of action. You can't sue over Rule 11. That's ridiculous. And of course, they refuse to be listed, but they to allow discovery topics related to the attorneys, that basically Guillard is demanding that Professor Scofield's attorney-client privilege be waived. That's bad. That's bad. A defendant can't demand the waiving of attorney-client privilege. That's so far beyond ridiculous. So the attorneys did not exercise due diligence which led to the need for the multiple claims in Ashley Guillard's counter-complaint. The attorneys continuously attempted to avoid accountability for their defamatory and perjurious actions against Ashley Guillard and for their lack of due diligence. This is exemplified by them refusing to waive service of the summons to the attorneys, filing a motion to quash the summons, and refusing to add their names to the discovery plan as counter-defendants after being served on the 9th of June. Due to the attorney's behavior, Ashley Guillard proposes the discovery plan for the court's consideration. And once again, they're not defendants. She claims they're defendants. They're not defendants. So most of this is the same, like I said. It's scope of discovery. So we already looked at Professor Scofield's scope of discovery. This is Guillard's. For defense and counterclaims, she wants just available for discovery the substantial truth of Ashley Guillard's statements about Rebecca Scofield's role in the murders. All evidence pertaining to it. She's the one that made it up. The substantial truth of Ashley Guillard's statements about Rebecca Scofield's relationship with Kaylee Gonsalves. The attorney's lack of due diligence before filing a civil complaint and failure to abide by Rule 11. The full details of the press release that defamed Ashley Guillard and all involved, who, what, when, where, why, and any payments related to it. Does she think that Professor Scofield or the attorneys were paid to? No. And all communication tools used by Rebecca Scofield personally and professionally to write and communicate with co-conspirators and collaborators in the creative arts, manuscript, and book writing process to resolve the issue of her involvement in the planning of the murder of the 4 University of Idaho victims. And this is so overly broad that and frankly abusive that lots of this is not going to be allowed. I mean, her book writing, other than Professor Scofield has alleged, hey, this defamation could hurt me from getting book deals, from getting published, and any communication to that level could be discoverable. But like drafts of her books that are completely irrelevant, no. All social media accounts created by Rebecca Scofield and her IP address on TikTok and Facebook to establish her connection to the creation of accounts on social media to continuously harass Ashley Guillard. First, Ashley Guillard has not alleged continuous harassment from Professor Scofield on social media. So how is any of that relevant? How is it relevant? And like that there's some social media might be relevant because you could say, all social media, all social media connections with the victims or whatever, all social media posts concerning the murders, but this is overly broad. All communication and financial accounts Rebecca Scofield use at the University of Idaho to establish a communicative and financial connection to the 4 University of Idaho students. Once again, that's ridiculous. Rebecca Schofield, personal and business financial records to establish a financial connection to the 4 University of Idaho victims and co-conspirators, and to establish payments to co-conspirators to harass Ashley Guillard. Rebecca Schofield's cell phone, tablet, computer, electronic device records to establish a connection to Kaylee Gonsalves and co-conspirators in the murder of the 4 University of Idaho students. Communications, documents, emails, personal and business phone records between Rebecca Schofield and Wendy Olson pre and post filing of the lawsuit to establish a personal prior relationship between the two prior to the filing of the lawsuit. She wants attorney-client communications. That once again, no. Can you see why Professor Scofield didn't agree to these? This is ridiculous. All work products between Rebecca Schofield and Stoll Reeves LLP attorneys, Wendy Olson, Elijah Watkins, Corey Carone, Tracy Horan, and assistants to establish the lack of due diligence and adherence to Federal Rule of Civil Procedure Rule 11 before the filing the frivolous claims against Ashley Guillard. No! Attorney work product is privileged. Like, if I asked for this, I'd be sanctioned. Me putting this in a discovery plan, in a request for discovery, this would be a violation of Rule 11. This is so far beyond the bounds of impropriety. Oh. Travel documents, arrangements, modes of transportation, rental cars, hotels, and lodging for Rebecca Schofield and immediate family members for the months of October and November 2022 to establish the substantial truth of Ashley Guillard's statements regarding Rebecca Schofield's role in the murder of the 4 University of Idaho victims. Which that probably will be provided because, you know, Professor Schofield put that. She said, hey, there's no way I committed these murders because I was in Oregon anyways. I wasn't anywhere near this. Excuse me. But then this travel documents, arrangements, modes of transportation, hotels, and lodging for Rebecca Schofield for the past 2 years to establish a connection to Kaylee Gonsalves and friends. Once again, that's ridiculous. That's abusive. That's so overly broad. And I should have put this at the beginning, but litigation is not a fishing expedition. You can't conclusively say, well, Professor Schofield had a relationship with one of the student victims, therefore I get to have access to any and all things that I allege prove a connection between them, and I get to discover them. You can't just go on a fishing expedition based on your conclusory statements. And Rebecca Schofield's alibi for the day prior to, the day of, the night of, and the next day following the murder of the 4 University of Idaho victims. And have I mentioned recently how much I despise Ashley Guillard? Ooh, she's awful. She's awful. Let's see. I think the rest of this is pretty much the same. I mean, but it is the same, but the irony here. So, documents protected from discovery, clawback. Pursuant to Federal Rule of Evidence 502D, the parties must request the court to enter an order that production of privileged or work product protected document, whether inadvertent or otherwise, is not a waiver of privilege or work product protection in this case or in any other federal or state proceeding. The court will enter such an order in its CMO unless the parties object. So Guillard is asking for privileged and attorney work product documents. She's demanding it. But let's move on and see if my head can explode from this one instead of from the proposed discovery plan. So, like I said, this is the now stricken response to the motion to dismiss the counterclaims. So, why am I doing this one, even though it's stricken, instead of this one? Well, frankly, because this one's 20 pages, and I have a feeling I know at least one place where she can save half a page real easily, and I want to read that part. And frankly, I want to see her whole argument rather than her condensed argument. And yeah, so we'll read this one instead. And introduction comes now. Counterclaimant Ashley Guillard in opposition to counter-defendant Rebecca Scofield's motion to dismiss counterclaims. Pursuant to Campbell v. Wells Fargo Bank from the Fifth Circuit in 1986, search denied by the Supreme Court in 1986, it is the standard that specifically, when deciding Federal Rule of Civil Procedure 12b6 motion, the court assumes all factual allegations contained in the complaint to be true, giving the claimant, to include counterclaimant Ashley Guillard, the full benefit of the doubt. Counterclaimant Ashley Guillard asserts that the statements she made in the factual allegations of the countercomplaint, to include that Rebecca Scofield ordered, planned, initiated, and ensured the execution of the murder of the 4 University of Idaho students, are substantially true. Given the full benefit of the doubt that the factual allegations in the countercomplaint is true, the 11 counterclaims Ashley Guillard filed are merited, states claims for relief, and are worthy of judication, as opposed to adjudication. And I would quibble that Campbell versus Wells Fargo Bank is a Fifth Circuit case when we're in the Ninth Circuit up in Idaho. Although the Fifth Circuit is in Texas, which is where Ashley Guillard is, but that's not where the court is. This is the national standard that, yeah, when deciding based on a 12b6 motion to dismiss for failure to state a claim upon which relief may be granted, the court assumes all factual allegations contained as true. But that's not where it ends. I should have pulled this up from the start, because I should have known it would come up, but it's our good friend Ashcroft versus Iqbal. And I'm just going to pull up the Wikipedia page just because it's going to be. So I don't know if I've ever given the background to Ashcroft versus Iqbal, but basically it was the petitioner Javed Iqbal, I don't know how to pronounce his name, sued the former Attorney General, U.S. Attorney General John Ashcroft. And so well, let's look at the background. He's a Pakistani-American cable television installer in Lower Manhattan when the World Trade Center was attacked. He'd been on his way to renew his work authorization card, as he was an immigrant and did not have permanent citizenship. In an initially unrelated action 8 weeks later, he was arrested on charges of conspiracy to defraud the United States and fraud in relation to identification documents, and he was placed in a pretrial detention at the Metropolitan Detention Center in Brooklyn, New York. When officers searched his apartment, they found a card for an appointment to be downtown on 9/11, as well as media reporting on the attacks and suspected him of involvement. So Iqbal alleged that FBI officials carried out a discriminatory policy by designating him as a person of high interest in the investigation of the September 11th attacks because of his race, religion, and national origin. He asserted that it was because of his identity as a Pakistani Muslim that he was placed in the detention center's administrative maximum special housing unit for over 6 months while he was awaiting the fraud trial. So, but the problem is, all of these were basically, it was all conclusory statements. And so he had conclusory statements that covered all of the requirements, all of the elements in the cause of action, but they were conclusory statements, and so that they weren't proper allegations. So for first line on the Wikipedia page, which Ashcroft versus Iqbal was a U.S. Supreme Court case which held that plaintiffs must present a plausible cause of action. Alongside Twombly, and together known as Twickball, Iqbal raised the threshold which plaintiffs needed to meet to survive a 12b6 motion. Further, the court held that government officials, okay, we don't need to worry about the government immunity portion, the qualified immunity. So let's look at the holding. So this isn't as much as I wanted. It held that the heightened fact pleading standards as required by Bell Atlantic versus Twombly apply to all federal court cases. But so remember, under the Rule 8 pleading standard, a complaint must contain a short and plain statement of the claim showing that the pleader is entitled to relief. Detailed factual allegations are not required. However, the court found that Rule 8 requires the non-moving party to show plausible factual allegations accepted as true to state a claim to relief that is plausible on its face. That's citing Twombly. A claim has facial plausibility when the pleaded factual content allows the court to draw the reasonable inference that the defendant is liable for the misconduct alleged. In so doing, the court confirmed that the standard set forth in Conley versus Gibson from 1957, which was the Supreme Court case that had defined Rule 8 pleading before Twombly and Iqbal, should not be followed in it. Basically, it overturned Conley versus Gibson. So the court restated the substance and application of Twombly for the Twombly test for the sufficiency of pleadings. So two working principles, that this is a quote from the case from Iqbal. Two working principles underlie our decision in Twombly. First, the tenet that a court must accept as true all of the allegations contained in a complaint is inapplicable to legal conclusions. Second, only a complaint that states a plausible claim for relief survives a motion to dismiss. Determining whether a complaint states a plausible claim for relief will, as the Court of Appeals observed, be a context-specific task that requires the reviewing court to draw on its judicial experience and common sense. In keeping with these principles, a court considering a motion to dismiss can choose to begin by identifying pleadings that, because they are no more than conclusions, are not entitled to the assumption of truth. While legal conclusions can provide the framework of a complaint, they must be supported by factual allegations. When these are well-pleaded factual allegations, a court should assume their veracity and then determine whether they plausibly give rise to an entitlement to relief. Our decision in Twombly illustrates the two-pronged approach. So, while Guillard is correct that, yeah, her assertions are to be taken as true, that's not the end of the analysis, because only plausible claims, and this is important. In keeping with these principles, a court considering a motion to dismiss can choose to begin by identifying pleadings that, because they are no more than conclusions, are not entitled to the assumption of truth. The court can dismiss all of her psychic BS because the court can say, hey, look, this is nonsense. This isn't factual. This isn't deserving of being accepted as true. So based on Twombly and Iqbal, the court can say, hey, all of this psychic nonsense carries no weight. So taking away all of this psychic nonsense and conclusory statements from Ashley Guillard, is there anything supporting her claims? No, there is absolutely nothing. Because it's all of her claims are Professor Schofield defamed me because she called me a liar by saying she didn't murder the students. But, I'm a psychic, so I know that she's lying, that Professor Schofield's the liar and the murderer, and you take that away, and it's just conclusory statements that Professor Schofield did it, and therefore she lied about me. But that's just conclusory, so it doesn't count. Under the Conley versus Gibson standard, that might have been enough, but it's not, because ever since Twombly in 2007, conclusory statements aren't enough. But that was a nice long tangent, but I think it was necessary. So let's get back to it. So I think this is where I was. Counterclaimant Ashley Guillard asserts that the statements she made in the factual allegations of the countercomplaint, to include that Rebecca Schofield ordered, planned, initiated, and ensured the execution of the murder, ensured the execution. Okay, so the execution, as in the carrying out of the murder, the wording just seemed strange, because you could have just said the execution of the University of Idaho students, but the execution, as in the carrying out of the murder of the 4 University of Idaho students, are substantially true. Given the full benefit of the doubt that the factual allegations in the countercomplaint is true, the 11 counterclaims Ashley Guillard filed are merited, states claims claim for relief, and are worthy of adjudication. Okay, well, that's where I finished before the tangent, because adjudication. Background. Rebecca Schofield planned, initiated, ordered, and executed the murder of the 4 University of Idaho students who were killed in Moscow, Idaho on November 13th, 2022. Rebecca Schofield went undetected by Moscow Police Department, Idaho State Police, and FBI detectives who were assigned to the case. On November 24th, 2022, Ashley Guillard used her psychic abilities, spiritual acuity, and investigative skills to uncover the motive and details that led to the murder of the students. She posted her findings on social media and reported it to the FBI tip line. To stop Ashley Guillard's information from being taken seriously and to silence her, Rebecca Schofield and her attorneys, filed a lawsuit against Ashley Guillard with 2 frivolous claims for defamation. Rebecca Schofield initiated the lawsuit with full knowledge that she was responsible for the death of the 4 students and with the intent to harass, embarrass, humiliate, and discredit Ashley Guillard and her spiritual practice. The attorneys worked concertedly on the lawsuit, Schofield versus Guillard. Together, they failed to exercise reasonable due diligence to ensure the truth of the claims against Ashley Guillard before filing her oath that the claims are true. Instead, they worked together with Rebecca Schofield to harass, embarrass, humiliate, and discredit Ashley Guillard, and to defraud her out of millions of dollars under color of law, using and abusing attorney and judicial immunity. To defraud her. Seriously. If they got a court judgment against her, that's defrauding her of millions of dollars? No. In their legal filings in the case, the attorneys collectively defamed Ashley Guillard as a purported online sleuth who used the murders of the 4 students to gain money and followers. The truth is, Ashley Guillard did not make any money from TikTok or in any way from reporting her findings. Instead, she lost followers, lost revenue, and suffered financial, mental, and business repercussions due to the false statements Wendy Olson made about her in multinational press releases and from filing of the frivolous lawsuit against her. The truth is, Rebecca Schofield is a serial killer. Jesus Christ. For starters, like, even if we take Ashley Guillard as true, that doesn't make Professor Schofield a serial killer. It would be a mass murderer. Or, like, I don't think this would even qualify as a spree killer, because like the difference between a spree killer and a serial killer is like time. Serial killers have time between killings. Spree killers, like, think about Ted Bundy. So if you take away all of his Washington and Idaho and Colorado and, yes, even Utah, maybe California, you take away all of that, okay? You just go with Florida, where he was finally caught and executed. So, and I do have actually stories about him in Utah, but that's not for today. Personal connections. But so, like, you look at it, his murders of the sorority girls on the campus, I don't know if that counts as a spree or not. But then murdering the little girl a few days later at a different location, I think that qualifies as a spree. So, but it wouldn't, I don't think, qualify him as a serial killer. Just on the Florida murders alone. But saying the truth is Rebecca Schofield is a serial killer, well, like, even if her allegations are true, this isn't. But Professor Schofield is a serial killer who successfully evaded suspicion of her crimes for months with the help of the attorneys. By defaming Ashley Guillard, by insulting spiritual practices like tarot readings, by mocking psychic intuition, denouncing spiritual connection, and mediumship as inauthentic, Professor Schofield and the attorneys deterred Rebecca Schofield from criminal investigation. Or maybe it was that actual, police investigation that led to Brian Kohberger and not Professor Schofield. In addition to the frivolous lawsuit filed against her and being defamed on multinational news media, Ashley Guillard was harassed. Hundreds of fake TikTok pages were created to comment on all of Ashley Guillard's social media posts, to call her crazy, and to attack anyone who attempted to defend her. How does she know that fake TikTok pages were created to comment on? I mean, and once again, yeah, Professor Schofield suing brought it to more people's attention, but, like, I'm not basing any of my commentary based on anything Professor Schofield has said. I'm basing it on, I think that psychics don't reel, to paraphrase the linguistic characteristics of fellow YouTuber Sir Sick. I think it's nonsense based on my own opinions. I formed my own opinions. I'm sure all of you formed your own opinions, quite independent from Professor Schofield suing. Ashley Guillard blocked those pages, and more were created. The intent was to cause Ashley Guillard's mental health to be questioned to prevent her statements about Rebecca Schofield from being taken seriously. As a result of their tactical strategy to destroy Ashley Guillard to prevent Rebecca Schofield from suspicion and investigation of quadruple murder, they collectively violated a multitude of Ashley Guillard's rights that resulted in at least 11 merited claims for relief. For these reasons, as set forth more fully below, Ashley Guillard respectfully requests the court to deny counter-defendant Rebecca Schofield's motion to dismiss. Legal standard. Counter-defendant Rebecca Schofield and her attorneys asked the court to dismiss Ashley Guillard's counterclaims for failure to state a claim upon which relief can be granted. Federal Rule of Civil Procedure 12b6. Their argument is that Ashley Guillard's counterclaims are implausible and that the court should use common sense and dismiss the counterclaims. More specifically, they're asking the court to debunk spirituality, mediumship, psychic abilities, and intuitive acuity as implausible. Doing so puts the court in the position to decide whether a spiritual practice is authentic. In the United States, citizens have the free will to choose to participate in their religious and spiritual practices. It is guaranteed by the First Amendment of the United States Constitution. The First Amendment provides that Congress makes no law respecting an establishment of religion or prohibiting its free exercise. Rebecca Schofield and her attorneys have already compromised Ashley Guillard's reputation, time, mental health, social media, business, finances, income, and overall livelihood to prevent Rebecca Schofield from being properly investigated for the murder of the 4 University of Idaho students. But the First Amendment doesn't mean that the court has to essentially take judicial notice that Ashley Guillard believes she's a spiritual medium, therefore it's true. I mean, the reality is, if the court were to say, well, all right, you say that the First Amendment provides that Congress makes no law respecting an establishment of religion or prohibiting its free exercise. Well, since you say being a spiritual medium is your religion, I have to enforce that on Professor Scofield. Well, that would be establishment of religion. It would be the government taking a position on an affirmative position on religion. So that violates Professor Scofield's rights. Now, they're asking the court to compromise a multi-billion-dollar industry, the metaphysical industry, and to compromise the parameters of the First Amendment of the United States Constitution to protect Professor Scofield, an accused serial killer who was not properly investigated. Their motion to dismiss does not meet the legal requirements. It's also unethical, disrespectful, distasteful, and unprofessional. Counterclaimant Ashley Guillard requests denial of the motions to dismiss. Yeah, I have a feeling I'm not making it to delete laws today. Argument. Counter-defendant Rebecca Schofield and her legal counsel suggests dismissing all of Ashley Guillard's counterclaims because they are implausible and legally deficient. Ashley Guillard disagrees. She argues that her claims are legally merited, pleaded with particularity, and meet the required legal intent and elements of each claim. Except, they don't even do that. Because, for starters, the defamation claim, like, she cited whatever USC section 4001, the federal definition of defamation, for the purpose of perfecting foreign defamation claims in federal court. So it basically said, this is what counts as defamation. So if your foreign defamation claim, well, judgment, I should say, if your foreign defamation judgment fits this definition of defamation, you can sue to enforce it under this statute. As Ashley Guillard does not have a foreign defamation judgment, Section 4001 is inapplicable. So she has not met the required legal intent and elements of those claims at the very least. Not to mention the 1985, which it involves a race-based element of discrimination, but only specific discrimination, and I can't remember what it is, but it's in the last video. So, but it doesn't apply, because, for starters, Professor Schofield isn't the government, so she doesn't meet the requirements of that statute anyways. But this isn't race-based in any way. Yes, Ashley Guillard is African American, but that's completely beside the point for the purposes of this lawsuit. But rant over. Counterclaims. First and second counterclaim for defamation, or counterclaim for relief, defamation. Counterclaimant Ashley Guillard incorporates by reference docket 20 in the Schofield versus Guillard case, paragraph 66 through 130 of the counterclaim. Well, that's one of the reasons why she's 11 pages, presumably, over the page limit. It took her 3 lines, well, 2 lines, just to reference the either way, let's keep going. Counterclaimant Ashley Guillard alleges that counter-defendants Rebecca Schofield and attorney Olson defamed her by publishing false statements of fact about her in the news media. Counterclaimant Ashley Guillard alleges that counter-defendants Rebecca Schofield and the attorneys defamed her by publishing false statements of fact about her in the frivolous lawsuit, Schofield versus Guillard. But even if those are false, it's privileged. It's litigation privilege. And by filing the frivolous lawsuit under oath. Did they file it under oath? That's a delete laws thing to do, but they didn't sign it as under oath. Counter-defendants reject Guillard's defamation claims because 28 USC section 4101, oh, I said 4001, but 4101 does not apply, and filing a lawsuit cannot give rise to a defamation claim. For the reasons above and below, Ashley Guillard disagrees. She can disagree till the cows come home. She's still wrong. Argument against legal deficiency. Pursuant to Carver versus Ketchum from the Idaho State Court, I don't see a year cited on there, and also Adair versus Freedom, also from, I presume, the Idaho Supreme Court, but still no date on either of those, so they're incorrectly cited. The general elements of defamation are that the claimant must prove that the defendant communicated information concerning the claimant to others, and the information impugned the honesty, integrity, virtue, or reputation of the claimant, or exposed the claimant to public hatred, contempt, or ridicule, and the information was false, and the defendant knew it was false, or reasonably should have known that it was false, and the claimant suffered actual injury because of the defamation, and the amount of damages the claimant suffered. The first counterclaim for relief, defamation in the news media, meets all elements of the defamation as required by Idaho law, except you pled 4101 as your cause of action, which isn't a cause of action. So you lose. The counter defendants communicated information concerning Ashley Guillard to others. It is a fact that is backed by evidence that Rebecca Scofield and attorney Wendy Olson issued a multinational press release to news organizations that reach billions of people worldwide and published or caused to be published false statements of fact about Ashley Guillard. Attorney Wendy Olson has been quoted stating that Ashley Guillard re-victimized the families of the slain students, which that would be opinion. Opinion is not defamation. That Ashley Guillard damaged Rebecca Scofield's reputation. Well, while that is true, it's also opinion because it's, well, it's a complex issue, but opinion is, or reputation is opinion based. So, you know, that Miss Guillard has continued to make false statements knowing they are false. That Ashley Guillard used the horrific tragedy of the murder of the 4 University of Idaho students for personal gain. That's also opinion. And more. Rebecca Scofield also made direct false statements about Ashley Guillard in her interview with the Spokesman Review, claiming that Ashley Guillard made false statements about her that has no grounding in truth. But now imagine the delusion, the absolute delusion it takes to think that Professor Scofield is defaming Ashley Guillard by saying, I'm not a murderer. I'm not a murderer. But that's defamation of Ashley Guillard because she says that Professor Scofield is the murderer. In what world does that make any sense? In what world does that work? And if you find that world, let me know because I want to avoid it at all costs. The statements were taken as fact and massively disseminated to, but not limited to, ABC Universal News, New York Post, CBS News, Time Magazine, skipping ahead, The Daily Beast, Insider.com, the Argonaut University of Idaho student newspaper, Apple Podcasts, multiple TikTok pages, Mama's Uncut. What's Mama's Uncut? The Tab, Fox 5 San Diego, Sandra Rowe's website, The Hill, the U.S. Sun, Reason website, NBC Right Now, DC News Now, Lawyer Pegleg Finance YouTube channel. That's me. Hey. But do you know what? Do you know what? Hang on. Let's scroll back up. The statements were taken as fact and massively disseminated to, but not limited to, me. I haven't seen any of her interviews, any of Professor Scofield's interviews. I have not seen Attorney Olson's interviews. I have not seen any of their news media. I have based the entirety of my opinion on Ashley Guillard on Ashley Guillard's social media, on her TikTok, and on her guano crazy legal filings. So you cannot, Ashley Guillard, you cannot attribute my impression of you to anything that Professor Scofield or her attorneys have said. Nothing. It's entirely based on you. Shame on you. Don't attribute anything I say to them. Don't attribute my opinions to them. It makes me mad. It really does. But she puts me in here as if I've been influenced by Professor Scofield or her attorneys. No, I have not. I've been influenced by you, by your actions. That's why I read this one instead of the non-stricken, shorter one, because, that's 2/3 of a page. That's easy to cut. And I wanted to respond to it. That's why we're reading the long one. That right there. The information impugned the honesty, integrity, virtue, or reputation of the counterclaimant, or exposed the plaintiff to public hatred, contempt, or ridicule. The false statements made about Ashley Guillard caused her spiritual practice, integrity, intuition, mental health, honesty, and virtue to be unfairly judged, ridiculed, and denounced. Once again, that's entirely on you. You charlatan. Many people, including the news media reporters, assumed the statements made about Ashley Guillard were true. She was denounced as a psychic person and as a business. I am denouncing you as a charlatan. She was subjected to a massive amount of online public harassment, ridicule, judgment, contempt, and hate. She received death threats on email and social media. She was continuously harassed online, receiving thousands of negative comments. No death threats. Don't do that ever to anyone. I know I don't have to tell my audience, but don't do it. And just don't even comment. Like, I think her main TikTok, where the bulk of the damage was done, is gone. I don't know if TikTok nuked it or if Ashley got rid of it, but I think she has secondary accounts. Don't even interact with those. Don't comment. Don't just, like I said, this isn't a petting zoo. This is a wildlife safari. Keep your arms and legs inside the vehicle. Don't pet the animals. Don't interact. The counter defendant knew it was false, or reasonably should have known that it was false. Rebecca Schofield knows that she planned, initiated, and ordered the execution of the 4 University of Idaho students because she did it. She also knows that she had a relationship with Kaylee Gonsalves because she did it. Those are some nice conclusory statements there. They don't mean anything, but they're nice conclusory statements. Attorney Wendy Olson did not conduct a reasonable inquiry into the truth or falsity of the allegations Rebecca Schofield made about Ashley Guillard. She accepted the statements as facts without reasonable due diligence as professionally required by the Model Rules of Professional Conduct and by Rule 11B of the Federal Rules of Civil Procedure. It was her job to know if the statements she made about Ashley Guillard in the news media and in the legal documents were true before she filed the case and before she made the statements. Attorney Wendy Olson failed this duty. As Ashley Guillard has not been privy to Wendy Olson's work product, she doesn't know what due diligence she did. And as I've said, Rule 11 is not a cause of action. She issued false statements about Ashley Guillard to the news media as a strategy to attack Ashley Guillard's character, degrade her, embarrass her, discredit her, and to humiliate her, as a strategy to evade suspicion of Rebecca Schofield, without regard to the truth or falsity of the statements. She published the false statements about Ashley Guillard as direct quotes from herself, not quotes from Rebecca Schofield. The counterclaimant suffered actual injury because of the defamation and the amount of damages counterclaimant Ashley Guillard suffered. Counterclaimant Ashley Guillard's personal life was negatively impacted by the defamatory statements. She missed time with family and friends. She lost friendships due to the false statements being unfairly accepted as true without inquiry. But if your friends thought that you were psychic, they wouldn't have believed. Like, if they actually thought she was psychic, it wouldn't matter, and she wouldn't have lost friendships. If she lost any real life friendships, it's because they found out, hey, I can't support this nonsense. Counterclaimant Ashley Guillard's spiritual practice was negatively impacted by the defamatory statements. Her First Amendment rights were threatened under the color of law. She lost current and potential customers. Her social media pages were unfairly targeted, which led to her TikTok user account being temporarily banned multiple times and then permanently banned. Guess that answers my question from a few minutes ago. She connected to her audience, followers, and customers using her TikTok page for over 6 years. Counterclaimant Ashley Guillard's damaged reputation could potentially cause rejection of business and employment opportunities. Counterclaimant Ashley Guillard suffered multi-millions in damages in current and potential damages. Imagine calling someone a murderer and then thinking that you deserve millions of dollars for them denying it. That's grade A delusion. The first and second counterclaims for relief meet all legal elements of defamation. The first counterclaim for relief, defamation, meets all elements as required by Idaho state law. The counter-defendant's allegation of implausibility is irrelevant. Ashcroft versus Iqbal and Bell Atlantic versus Twombly would beg to differ. plausibility is an issue, even at the 12b6 stage. Should we take a look at it again? Second, only a complaint that states a plausible claim for relief survives a motion to dismiss. Directly from Iqbal, or at least from the Wikipedia page, but like I said, I went to Wikipedia for ease of access. I have read Iqbal in its entirety. It's a long one. It's dense. You're welcome for going straight to Wikipedia. But let's say that again. Only a complaint that states a plausible claim for relief survives a motion to dismiss. And yet somehow Guillard thinks the counter defendant's allegation of implausibility is irrelevant. Should we telephone SCOTUS and tell them, hey, you got this wrong in Iqbal because some psychic weirdo in Texas thinks that she doesn't need to plead a plausible cause of action? The authenticity or plausibility of metaphysical spiritual practices like tarot readings and psychic readings is not in question. It is. Besides which, prove it. Prove you're a psychic. Prove it. Make a plausible allegation. Make a plausible legal pleading to show you're a psychic, to show that psychics are real, to show that tarot readings are real. I mean, tarot readings are like the actual actions are real, but show that they're legitimate. Show it. You've got the burden. Nor is it constitutional to seek the court's legal opinion on the accuracy of a religion or spiritual practice. So let me get that straight. It's not constitutional to seek the court's legal opinion on this nonsense. So it's unconstitutional for the court to rule that you made this up. So based on the First Amendment, you can defame anyone you want. You can say anything you want. You can do anything you want and say, well, it's my religion. Now, yeah, religion does have a lot of protections. Some would argue too many. But this isn't one of them. Not by a long shot. At least not as she's trying to have it applied. I mean, imagine if Professor Scofield said, well, it's my religion. Human sacrifice is my religion. And yeah, those 4 unfortunate students were my human sacrifices. And court, you can't persecute my religion. You can't send me to jail. That was my religion. I think Ashley Guillard would scoff. You can't do that. That's not how it works. It doesn't work here either. The false statements the counter defendants made in the news media and in legal documents about Ashley Guillard are the subjects of the first and second counterclaims, not the plausibility of a spiritual practice. The false statements meet all elements of defamation, ergo are plausible. But here's the thing. Here's the thing. Here's the thing. I know this is a difficult concept for Ashley Guillard to understand. I know this is a difficult concept, but she says the false statements the counter defendants made in the news media and the legal documents about Ashley Guillard are the subjects of the first and second counterclaims, not the plausibility of spiritual practice. Without the spiritual practice, there's nothing but, absolutely nothing but conclusory statements. It's entirely conclusory statements. And remember, Twombly says conclusory statements, even if the conclusory statements meet the causes of, the elements of the cause of action, conclusory statements don't survive a motion to dismiss. You have to allege actual facts. You don't have to allege the full story, but you have to at least allege enough. Guillard is trying to say, well, my conclusory statements survive because of my conclusory statement that I'm a medium. But you can't look at my conclusory statement that I'm a medium because that violates my First Amendment. And it's irrelevant anyways. So you've got to just accept that I'm a medium, and therefore my conclusory statements survive. No, because there's still the plausibility standard, and the court can say, I find it implausible that you're a medium because that's not real. You may believe you're a medium, and you have the First Amendment right to believe that you are a medium, but I do not have to take judicial notice that you are a medium, that it is real. I don't have. That's the end of it. The counter-defendant's allegation that counterclaimant Ashley Guillard's claims should be dismissed because they did not make a state law defamation claim is not grounded in law. Rule 9 of the Federal Rule of Civil Procedure does not require legal technical terminology. A general, concise, direct allegation or claim for defamation that meets the elements is all that is legally required. Except you put it in the headline. You put, the cause of action is Section 4101. And they said, hey, this isn't a state law defamation claim. You're suing under 4101. That's not a thing, at least not as applied. Dismissed. The counter-defendant's allegation that counterclaimant Ashley Guillard's claims should be dismissed because they do not have direct or circumstantial evidence is not legally sufficient. Rule 11b3 of the Federal Rules of Civil Procedure allows pleadings that will likely have evidentiary support after a reasonable opportunity for further investigation or discovery. During the opportunity for discovery, Ashley Guillard plans to seek and provide evidence for all 11 counterclaims and defenses to the complaint. But once again, Rule 11 doesn't allow for fishing expeditions. You've got to have enough in the complaint to survive the motion to dismiss. If you don't have enough to survive the motion to dismiss, you don't get to discover. This isn't a chicken or the egg situation. Argument against absolute privilege. The counterclaim defendants claim that absolute privilege allowed them to file the frivolous claims and to publish false statements of fact about Ashley Guillard. They claim that pursuant to Berrien versus Berberian from the Idaho Supreme Court in 2020, which says, Idaho has long recognized that defamatory statements made in the course of a judicial proceeding are absolutely privileged, even if made with malicious intent or knowledge of their falsity. The counterclaim defendants failed to mention that Berrien versus Berberian's defamation claim was the result of a criminal arrest and a police report, not a federal civil lawsuit seeking damages under false pretense, false allegations, and a frivolous claim. But I get that she's trying to distinguish, but if you're going to distinguish and say, hey, this case that they cited doesn't count, you've got to bring a case of your own to say this is the one that actually counts. And it says, hey, if they sued for defamation in federal court, there's no privilege whatsoever. There's no litigation privilege. Litigation privilege only applies to state criminal proceedings. The reason Guillard hasn't brought that case is because it doesn't exist. There's an inherent difference in state criminal judicial proceedings and federal civil judicial proceedings. Federal civil cases are governed by Federal Rule of Civil Procedure 11b, and the Federal Rule of Civil Procedure bars frivolous claims presented for an improper purpose and that are illegal. Does she think that there isn't an equivalent to Rule 11b in every court? Does she seriously think that the Idaho state rules of civil procedure or the rules of criminal procedure don't have the equivalent to Rule 11b? They do. I'm not going to look them up, but they exist. They might not be an exact, but they exist. And as I said, Rule 11b is not a cause of action. It's a mechanism for sanctions. It doesn't give you it doesn't breach the immunity, the litigation immunity from defamation. Because let's think about it for a minute. Let's think about it for a minute. If there weren't litigation immunity in all cases, federal, state, criminal, or civil. If there weren't litigation immunity, what would happen? In every single case, once it's over, the winner's going to sue the loser for defamation, because they're going to say, hey, you brought facts that I don't agree with, that defamed me, therefore I'm suing you, and you'll just have perpetual litigation. Pursuant to the Supreme Court of Texas, we're in Idaho. What does the Supreme Court of Texas have anything to do with this? But pursuant to the Supreme Court of Texas, number 19-0036, Landry's Inc. et al. Versus Animal Legal Defense Fund et al. Argued 2021. So that looks like an unpublished state law case from a different state, but the intent of judicial privilege. This isn't judicial privilege. This is litigation privilege. Judicial privilege applies to the judge. The intent of judicial privilege is to facilitate the administration of justice by promoting full and free disclosure of information by participants in judicial proceedings, and it protects statements made in the due course of a judicial proceeding. As so, there are two elements required for judicial privilege to apply: due course of justice and the facilitation of the administration of justice. The due course of justice refers to the process of legal proceedings that follow established rules and principles to protect and enforce rights. Justice refers to the fair and proper administration of law. It is the quality of being just, in conformity to truth, impartiality, fair representation of facts, merit, and just treatment. In federal civil court, the filing of a frivolous claim, falsifying factual allegations to meet the requirements of a cause of action, and presenting a claim for an improper purpose is not within the intent of the due course of justice, nor does it facilitate the administration of justice. It hinders it. Additionally, it is a violation of Rule 11b and the Federal Rule of Civil Procedure, punishable by sanctions. But sanctions isn't a separate cause of action. A defamation lawsuit filed in the federal district court by the representatives of a serial killer against Ashley Guillard for exposing their client as the initiator, planner, and co-conspirator responsible for quadruple murders and for the purpose of evading suspicion, harassment, and to steal property is not a just action protected by law or judicial privilege. I mean, Ashley Guillard, if litigation privilege did not exist, she'd really wish it did, because Professor Scofield would institute a new claim for defamation for the multiple instances of Ashley Guillard calling her a serial killer. That's new defamation, but it's privileged because it's within the litigation itself. So I don't remember where I was in that, so I'm just going to start at the beginning of that paragraph. A defamation lawsuit filed in federal district court by the representatives of a serial killer against Ashley Guillard for exposing their client as the initiator, planner, and co-conspirator responsible for quadruple murders and for the purpose of evading suspicion, harassment, and to steal property. To steal property? That's a new one. So now you're alleging she's a thief. More defamation. Is not a just action protected by law or judicial privilege. Said behavior warrants civil and criminal actions. Allowing alleged criminals to be protected by judicial privilege and to allow them to use it to file frivolous claims with malicious intent unfairly positions witnesses. You're not a witness. No one is calling you as a witness. The state of Idaho is not calling you as a witness. If Brian Koberger calls you as a witness, his attorneys will have their licenses on the line, let me tell you that. No one is calling you as a witness in the criminal case. But apparently it's a malicious intent to unfairly position witnesses, people who send tips to investigators, and people brave enough to confront and expose criminals in a position to be maliciously targeted, harassed, and frivolously sued under the color of law. It is not in the best interest of justice, and it abuses the system that administers justice. So, here's a tip. If you think someone committed the crime, you don't go on TikTok. You go to the police. And if the police say, thank you, try again, you move on. You don't go on TikTok because that exposes you. Even if you think you're a witness, it exposes you to this. So it's not in the best interest of justice, and it abuses the system that administers justice. For these reasons, counterclaimant Ashley Guillard that's an excellent sentence. For these reasons, counterclaimant Ashley Guillard to deny the counter-defendant's motion to dismiss the first and second counterclaims for defamation. We're on page 11, and she's only through the first 2 claims. 2 out of 11. Ugh. Third counterclaim for relief, 42 U.S.C. Section 1985. Like I said, this one, Professor Scofield is not a state actor, so this doesn't apply. This was not done on the basis of Ashley Guillard's race, so this doesn't apply. But let's see why she thinks it does apply, shall we? Counterclaimant Ashley Guillard incorporates by reference, blah, blah, blah. That's, once again, a very long incorporation. And, like, this isn't even well done. Just citing 20 paragraphs at the start of your argument. You've got to be more particular than that. Like, when you bring up a particular portion of the argument, that's when you cite 1 or 2 paragraphs, usually at, Counterclaimant Ashley Guillard alleges that counter-defendants Rebecca Schofield and the attorneys conspired to interfere with Ashley Guillard's constitutional rights to due process and the freedom of speech, resulting in a cause of action under 42 U.S.C. Section 1985. Counter-defendants argue against Ashley Guillard's counterclaim, alleging that it is implausible because it isn't race-motivated, rely on group pleadings. Their conduct is immune by attorney-client privilege, states Ashley Guillard is not a party to Mr. Koberger's case, and alleges Ashley Guillard hasn't stated the right type of harm. Counterclaimant Ashley Guillard disagrees with the counter-defendant's arguments for the reasons set forth below. Argument against 42 U.S.C. Section 1985 implausibility due to a lack of race-based motives. The pertinent aspect of 42 U.S. Code Section 1985, sub 2, allows for a cause of action if two or more persons conspire for the purpose of impeding, hindering, obstructing, or defeating in any manner the due course of justice in any state or territory with intent to deny any citizen the equal protection of laws or to injure him or his property for lawfully enforcing or attempting to enforce the right of any person or class of persons to the equal protection of the laws. In any case of conspiracy set forth in this action, if one or more persons engaged therein do or cause to be done any act in furtherance of the object of such conspiracy, whereby another is injured in his person or property, or depriving or having and exercising any right or privilege of the citizen of the United States, the party so injured or deprived may have an action for the recovery of damages occasioned by such injury or deprivation against any one or more of the conspirators. She cited the whole thing. She cited the whole case. Sorry, the whole statute. As the statute states in plain language, the main premise and intent of 42 U.S.C. Section 1985 is to allow for a cause of action against conspirators conspiring to interfere with civil rights. The statute does not include race as a required element. Civil rights are personal rights, guaranteed and protected by the United States Constitution and federal laws to all United States citizens. 42 U.S. Code Section 1985 is not limited to race-based intentions. It protects all United States citizens who meet the elements of its plain language. She's going to make me look it up again. She's really going to make me look it up again. She's going to make me look it up again. So it's obstructing justice, intimidating party, witness, or juror. That's what this is for. Section, and just wherever, I'm on 42 USC Section 1985. Let's click back over here. She's the pertinent aspect of 42 U.S. Code Section 1985, sub 2. So we're looking at sub 2, obstructing justice, intimidating party, witness, or juror. In order for her to have a 1985 case, like a bare minimum threshold, well, she can't say, well, you filed a lawsuit against me, therefore making me a party to that lawsuit, and I was intimidated by that lawsuit that I'm only a party of because you filed it against me, therefore I can sue you for 1985. That doesn't work. That's circular. So she's not a party to the Idaho murders. She's not a defendant. She's not the state of Idaho. She's not a victim. So she's not a party. she's not a witness. Like, she thinks she's a witness, but she's not a witness. The state of Idaho is not going to call her as a witness. The state of Idaho has not identified her as a witness. The state of Idaho has not identified her as a potential witness. Professor Schofield has not sued her on the basis of preventing her from being a witness. She has sued her for defamation, not to stop her from being a witness. And she's most certainly not a juror. She's not a resident of the state of Idaho. She's not eligible to be a juror in Idaho. And let's see. I remember there was a race-based aspect to this, but I'm not seeing it. But that might have been the accompanying 1986. So no. Either way, I've been going too long to get bogged down, but needless to say, she forgot a very important aspect of 1985 sub 2, meaning she's not a party witness or juror in the Brian Kober case. So she fails on that. Like even if there isn't a race-based element to it, but which, like I said, I'm not going to search for. It's in a past video. It's there. I'm just not seeing it because it's been a long day and my head is ready to explode from this nonsense. So, but she says the statute does not include a race as a required element. Civil rights are personal rights, guaranteed and protected by the United States Constitution and federal laws to all United States citizens. 42 U.S.C. Section 1985 is not limited to race-based intentions. It protects all United States citizens who meet the elements of its plain language. But its plain language requires you to be, at least for sub 2, a party, witness, or juror. Counter defendants quote Jones versus Norton from the 10th Circuit in 2015, a civil rights case arising from a Ute tribe member, Todd R. Murray, being killed by police for not following an order, in which a 42 U.S.C. Section 1985 claim was denied because the court decided that an action under 42 U.S.C. Section 1985 sub 2 requires a showing of some racial or perhaps otherwise class-based invidiously discriminatory animus behind the conspirators' action. That decision was not based on the plain language of 42 U.S.C. Section 1985 statute and reflects the ideology of the United States Court of Appeals for the 10th Circuit. Ashley Guillard disagrees with the counter-defendant's references as unpersuasive because the Constitution clearly and plainly states the intent behind 42 USC section 1985 claims is to deny. Now, hang on. That almost slipped past, but I've got to stop that. And it's not that she disagrees, because it's unpersuasive, as ridiculous as that is. But the Constitution states the intent behind a statute. No. The court case states the intent of the statute, interprets the statute. The statute is passed under the authority of the Constitution, but that she's getting it backwards. Oh. But the Constitution clearly and plainly states the intent behind Section 1985 claims is to deny any citizen the equal protection of the laws, or to injure him or his property for lawfully enforcing or attempting to enforce the right of any person or class of persons to the equal protection of the laws. So wouldn't that class of persons and equal protections of the law, that kind of hints that there has to be some sort of unlawful discrimination? Because, like, I can discriminate you for almost any reason. It may make me a jerk, but it's not illegal. It's only illegal discrimination that's illegal. And that's generally going to be based on some protected class, or if there's a statutory mandate that you can't discriminate against this, So, funny enough, Section 1985, well, she's not part of the class it protects anyways, because she's not a juror, witness, or a party to the Brian Kohberger case. But the statute clearly states any person or class of persons. Race is a class of persons that is included in the population of any person governed by the United States Constitution. I really think it's in here somewhere. But I'm not going to get bogged down. I know I saw it. It might have been in a comment on the different website that I looked it up on, Justia as opposed to Cornell, but I know it was there because I brought it up before the attorneys for Professor Scofield, so I know it's there. The counter-defendant's argument that the U.S. District Court for the District of Idaho should adopt an advantageous rule from the 10th Circuit because they think the decision to add race as an element to 42 U.S.C. Section 1985 claims is more beneficial to the counter-defendant's motion to dismiss. However, it is not. The case decision also includes otherwise class-based invidiously discriminatory animus as an alternative to the element of race. What class? It's got to be a protected class. When it says class-based invidiously discriminatory animus, it's got to be a protected class. And once again, like, witnesses are not class protected specifically by the Civil Rights Act. It's specifically Section 1985 that makes them a protected class for the purposes of Section 1985. But she's foreshadowing spiritual practice is her class, that she's the class-based discrimination. Ashley Guillard's spiritual practice was denounced and targeted by the defendants and improperly shamed as implausible, fantasy-based, and dishonest. The counter-defendants vehemently asked the court to decide that spiritual practices, as in tarot readings, and spiritual connections, as in mediumship and psychic intuition, is implausible, seeking that the court discriminate against Ashley Guillard based on their denunciation of her spiritual practices. Title VII of the Civil Rights Act of 1964 includes not only traditional organized religions such as Christianity, Judaism, Islam, Hinduism, and Buddhism, but also religious beliefs that are modern, like the broad parameters of spirituality, uncommon, not part of a formal church or sect, like paganism, only subscribed to by a small number of people, or that seem illogical or unreasonable to others. But you're asking the court to accept the court can absolutely accept that you believe this. It doesn't have to accept like if I say, I mean, I don't believe in the flying spaghetti monster. Well, I do believe in this flying spaghetti monster, don't get me wrong, but I think he's a jerk. I worship the Grand Linguini. He's the real, you know, the Grand Linguini. Reformed Church of Pastafarianism here. But the court can absolutely say, hey, Joe believes in the Grand Linguini. The court does not have to accept that the Grand Linguini exists. He totally does. Title VII of the Civil Rights Act protects all aspects of religious observance, practices, as well as beliefs. The counter-defendants discriminated against Ashley Guillard based on her spiritual beliefs and practices. Therefore, this 42 U.S.C. Section 1985 counterclaim meet the element of showing of some racial or perhaps otherwise class-based invidiously discriminatory animus behind the conspirators, as required by the 10th Circuit. The U.S. District Court for the District of Idaho is one of the 15 districts within the federal judiciary of the 9th Circuit. Decisions of law made in other jurisdictions are generally not legally binding. They're persuasive. It is the court's discretion to adopt ideological-based case decisions made in other jurisdictions. Counterclaimant Ashley Guillard respectfully requests the court decline the invitation to adopt the 10th Circuit's added element of race to 42 U.S.C. Section 1985 claims simply because it is not based on the statute as plainly stated in the United States Constitution. The Supreme Court used a 9th Circuit decision in part as a decision-making reference in a 42 U.S.C. Section 1985 claim. The Supreme Court in Haddle versus Garrison, but it being a 9th Circuit case gives it no extra weight. It's the Supreme Court. And like if you're trying to bolster it, like if the Supreme Court affirmed the Ninth Circuit ruling, just either cite the Ninth Circuit ruling because that's good law in the Ninth Circuit. That's binding in the Ninth Circuit. It's not persuasive, it's binding. Binding. But if you like the language of the Supreme Court better, cite the Supreme Court. That's also binding on all circuits. But if the Supreme Court overturned the Ninth Circuit opinion, why even cite? Why even bring up that the case originated in the Ninth Circuit? That doesn't give it any extra weight. It's a Supreme Court case. It is binding on all circuits. The Ninth Circuit case is not binding on any circuit because it was overturned. And I got ahead of myself a little bit. Should have read one line further. The Supreme Court used a Ninth Circuit decision in part as a decision-making reference in a 1985 claim. The Supreme Court in Haddle versus Garrison reversed and remanded. So it doesn't matter that it's from the Ninth Circuit because the Supreme Court said, this is bad law. Get rid of it. So the Supreme Court law is the good law. Just cite the Supreme Court. It does not matter that it came out of the Ninth Circuit. I mean, it was remanded, so, you know, maybe the decision that came after the remand. So here's how it usually works. Here's how it usually works. The Supreme Court, when it overturns, it doesn't say, here's the result. It says, this is what the law is. Now, lower courts, you decide it based on what we just said the law is. So, you know how, at least I think I complained. Yeah. I mentioned this, I think, in the last video, if not the one before. It's been a little while, so I forget. But I mentioned, yeah, it was on the what was it? It was talking about the Younger doctrine, or no, it was the delete laws video where the Jensen guy tried to intervene, and I was talking about intervention, and it was Hollingsworth versus Perry, I think. So remember, it originated Perry versus Schwarzenegger, and then became Perry versus Brown on appeal because Schwarzenegger was replaced by Jerry Brown as governor of California. This was Perry sued to overturn Proposition 8 in California, which outlawed gay marriage. The state of California did not defend Proposition 8. They didn't defend the case. And so Hollingsworth, who had been a sponsor of Proposition 8, tried to intervene. And it went to the Supreme Court, and the Supreme Court said, yeah, we're not ruling on Proposition 8. We're ruling that you can't intervene, reversed and remanded based on you not being able to intervene. So the Supreme Court, if they can, they're just going to rule on a technical issue, on procedure. And so, like, the effect of the Supreme Court ruling was gay marriage became legal in California based on the Supreme Court ruling. But that didn't apply to any other state because they made the ruling as narrowly tailored as possible about intervention. So the next year, when the state of Utah in Kitchen versus Herbert, it went to, it was decided, I think, on summary judgment in favor of Derek Kitchen, and it made gay marriage legal in Utah. That was the next domino to fall. And the Hollingsworth versus Perry had absolutely nothing to, this wasn't an intervention case. The Perry versus Schwarzenegger, well, that was, it was persuasive, but so this was a long tangent, but what I'm getting at is, why was this reversed and remanded? Was it because they applied the substantive law wrong, the 1985 claim wrong, or did they remand it because of a pleading problem, because of rule of civil procedure problem? Was it a standing problem? What, an evidentiary problem? I don't know. But what I'm saying is, based on what I've seen so far, I don't know if it was reversed and remanded because they said, no, you got the law wrong. This is what the law on 1985 claims is, the Supreme Court. And so lower courts, you need to make a ruling in accordance with that. Or was it reversed and remanded because they said, hey, this was based on hearsay, just this was based on hearsay, therefore the evidence was wrong, so we remand and you've got to rehear the case without the hearsay. And they might have came to the same conclusion in the end. But yeah, that was a long tangent, I realize, and it could have been irrelevant even, but that's how the Supreme Court often decides appeals. So the Supreme Court in Haddle versus Garrison reversed and remanded, argued November 10th, 1998, and decided December 14th, 1998. Conferred to the 42 U.S.C. Section 1985 statute to decide on the requirements of 42 U.S.C. Section 1985 claims, stating that the language or purpose of the prescriptions and its attendant remedial provisions are what establishes the requirements of the cause of action. Race is not an element as written in the statute's plain language. Did the Supreme Court say this? Like, Is this a direct quote of the Supreme Court that race is not an element as written in the statute's plain language? If it is, I'd do this as a direct quote. The purpose of its prescriptions is to protect United States citizens from the deprivation of federal rights. But what federal right is it? What federal right is it? What federal right does Section 1985 protect? TikToking? I don't think so. Counterclaimant Ashley Guillard respectfully requests that the court align with the decision of the Supreme Court in Haddle versus Garrison. Argument against the allegation of lack of specificity in group pleadings. Counterclaimant Ashley Guillard claims joint and several liability for all counter-defendants for each counterclaim. Joint and several liability is supported by Rule 11C1. In general, after notice and a reasonable opportunity to respond, the court determines that Rule 11B has been violated. The court may impose an appropriate sanction on any attorney, law firm, or party that violated the rule or is responsible for the violation. Absent exceptional circumstances, a law firm must be held jointly responsible for a violation committed by its partner, associate, or employee. Like Rule 11C1, co-conspirators to a civil offense may be held jointly liable. How many times do I have to say Rule 11C isn't a cause of action? If co-conspirators in a civil offense may be held jointly liable, cite that. Cite how. Rule 11C is not what makes it possible. Besides which, an attorney filing suit on behalf of a client doesn't make them co-conspirators in anything. It makes them an advocate for their client. Joint and several liability is supported by 42 U.S.C. Section 1985, sub 3. If one or more persons engaged therein do or cause to be done any act in furtherance of the object of such conspiracy, whereby another is injured in his person or property or deprived of having and exercising any right or privilege of a citizen of the United States, the party so injured or deprived may have an action for the recovery of damages occasioned by such injury or deprivation against any one or more of the conspirators. So, Section 3 of Section 1985, depriving persons of rights or privileges. If two or more persons in any state or territory conspire or go in disguise on the highway or on the premises of another for the purpose of depriving, either directly or indirectly, any person or class of persons of the equal protection of the laws, or of the equal privileges and immunities under the laws, or for the purpose of preventing or hindering the constituted authorities of any state or territory from giving or securing to all persons within such state or territory the equal protection of the laws, or if two or more persons conspire to prevent by force, intimidation, or threat any citizen who is legally entitled to vote from giving his support or advocacy in a legal manner toward or in favor of the election of any lawfully qualified person as an elector for president or vice president, or as a member of Congress of the United States, or to injure any citizen in person or property on account of such support or advocacy in any case of conspiracy set forth in this action. If one or more persons engaged therein do, or cause to be done, any act in furtherance of the object of such conspiracy, whereby another is injured in his person or property, or deprived of having and exercising any right or privilege of his citizen, have an act for the recovery of damages occasioned by such injury or deprivation against any one or more of the conspirators. So, yeah, Section 1985 sub 3 does have a provision for joint or several liability. What it doesn't have is anything about defamation, or how defamation is alleged defamation, I should say, deprives you of your civil rights. Because this is depriving, like, if two or more persons conspire to go in disguise on the highway or the premises of another for the purposes of depriving them of their civil rights. Well, they didn't go in disguise on the highway or on the premises of another. So it doesn't count for that. For the purposes of preventing or hindering the privileges or immunities. No, because privileges or immunities, I'm sure most of you watching this are familiar with the broad provisions of the Privileges and Immunities Clause of the Constitution and the Privileges or Immunities Clause of the Constitution. Because if you're here, you probably are familiar with sovereign citizens and their arguments about the right to travel, which the Privileges and Immunities and Privileges or Immunities Clauses are generally considered, are where the so-called right to travel comes from. And the right to travel, the privileges and immunities, is basically, if you're a citizen of one of the states, you have the privileges and immunities of other states. So if I'm on Social Security in the state of Utah and I move to the state of California, and the state of California says, hey, you don't qualify until you've lived here for 6 months. I say, hey, I'm a citizen of the United States. I qualify right now. Thank you very much. Or, sticking to the right to travel. If I move to the state of California and they say, you've got to wait 6 months before you can apply for a California driver's license. Hey, I'm now a resident of California. I can get it right now. Thank you very much. But there's no, what privileges and immunities are being abrogated, or, if two or more persons conspire to prevent by force, intimidation, or threat any citizen who is lawfully entitled to vote from giving his support or advocacy in a legal manner toward or in favor of the election of any lawfully qualified person as an elector for president or vice president, or as a member of Congress of the United States, or to injure any citizen in person or property on account of such advocacy or support. That doesn't apply here. This isn't about an election, or, Ashley Guillard's preferred candidate for an election, or trying to silence her advocacy for such candidate. So that doesn't apply. So I don't see anywhere where Section 3 applies. Do you? I mean, she conveniently cites, let's take a peek. she cites the blue highlighted part, but that completely leaves out all of the conditions precedent for the cause of action to even exist. Convenient, don't you think? She really needs to use quotation marks at the very least. I mean, this, it doesn't want to highlight on the PDF, but 1, 2, 3, 4, 5, about 5 lines. That probably should have been a block quote anyway, but at the very least, since this whole thing is a direct quote, you've got to use quotation marks. Come on, that's English 101. I'm nitpicking, of course, but you've got to do it. She's not paraphrasing, so you've got to make it clear that that whole thing is a quote. But joint and several liability is supported by the joint action test. A plaintiff can show joint action either by proving the existence of a conspiracy or by showing that the private party was a willful participant in joint action with the state or its agents, citing Sow versus Desert Place, Inc. from the Ninth Circuit in 2012. Ashley Guillard pleaded the counterclaim with particularity. As stated in her answer and counter-complaint, the goal of the co-conspirators was to prevent Rebecca Scofield from suspicion of the murder of the 4 University of Idaho students. To accomplish that goal, the co-conspirators conspired to discredit, harass, embarrass, and humiliate Ashley Guillard, and conspired to deprive Ashley Guillard of the 14th Amendment right to due process and the First Amendment right to the freedom of speech. Rebecca Scofield, in joint action with the attorneys, filed a frivolous defamation claim, Scofield versus Guillard, against Ashley Guillard with the intent to illegally deprive Ashley Guillard of the freedom of speech, the freedom to freely engage in spiritual practices, of an impartial tribunal of nearly $2 million in falsified damages. They're trying to deny her of an impartial tribunal by suing her in federal court, which is an impartial tribunal. That doesn't make sense. And $2 million in falsified damages. Like, yeah, the $2 million figure that we saw in the motion for default, the motion for a default judgment, that, like, yeah, the $2 million figure, that's not exact, because how do you measure the impact of defamation? I mean, like, yeah, you can say I lost out on this specific, you know, if you're Johnny Depp, you can say I missed out on Pirates of the Caribbean 6, which would have paid me $50 million due to Amber Heard's defamation. Therefore, I want Amber Heard to compensate me for that $50 million that I would have received but for her defamation. What's a but for? Pooping. But in this case, you know, we don't know what the damages are. But you know, Professor Schofield laid out pretty succinctly, you know, this is my salary. She put me, put that salary at risk. I get book deals. She put that at risk. So, you know, based on 10 years of, you know, I basically I want 10 years of liquidated damages. Um, that could be end up being a bargain for Ashley Guillard. It could be that, you know, there was $10 million of actual damage, but we don't see it yet. The jury might say, yeah, there's, you know, there's a whole lot more damage than that. Um, she cited the Cardi B, what is it? Tasha K versus Cardi B versus Tasha K, I think. Um, I didn't cover that at all. I can't remember what the exact case citation is because Cardi B and Tasha K are not their real names. Imagine that. But Emily D. Baker fully covered that case. It's also a defamation case. And Professor Schofield used the same logic as Cardi B did in calculating damages. So, is it speculative? Sure. Is it falsified damages? Absolutely not. Besides which, Professor Schofield asking for $2 million in damages has absolutely nothing, no relevance whatsoever to the sufficiency of these counterclaims. So why even bring it up? Why put it back in the judge's mind that, yeah, this is the amount of damages that Professor Schofield suffered? Ignore it. Your counterclaims have absolutely nothing to do with Professor Schofield's claims. The frivolous claim was filed and signed by attorney Wendy Olson, listing Rebecca Schofield as the plaintiff and the attorneys as joint legal pursuant to 42 USC section 1985 sub 3, and is particular because they all engaged, acting as one unit, in the conspiracy to deprive Ashley Guillard of her constitutional rights. What constitutional right is it? Because she says First and 14th Amendment. First and 14th Amendment aren't listed in Section 3. They're not listed in Section 3. So the 1985 doesn't apply, period. At least 1985 sub 3 doesn't apply. 1985 sub 2 doesn't apply because she's not a party, witness, or juror. 1 doesn't apply because she's not an officer performing her duty. Because that would be, officer would be any person from accepting or holding any office, trust, or place of confidence under the United States, or from discharging any duties thereof. So she's not an officer of the United States performing her official duties. She claims to be a combat veteran, so she was. I assume that Section 1 actually would apply to soldiers. I'd have to look into it more, but I assume it. But let's keep going. So, therefore, in this counterclaim, joint liability is appropriate, Section 2, 1985, Sub 3, and is particular because they all engaged, acting as one unit, in the conspiracy to deprive Ashley Guillard of her constitutional rights, and Professor Scofield and Attorney Olson caused acts in furtherance of the object of such conspiracy to include pushing out press releases regarding the lawsuit, publishing the false statements about Ashley Guillard, and filing further motions and pleadings, including the motion seeking $2 million in fake damages. Argument against attorney immunity. The counter defendants allege that a claim under 42 U.S.C. Section 1985, Sub 2 arises if two or more persons conspire to obstruct justice. Quoting Faries versus Shearer from the 11th Circuit in 2003, as long as an attorney's conduct falls within the scope of the representation of his client, such conduct is immune from an allegation of a Section 1985 conspiracy to elude accountability for their fraudulent actions. Defending Rebecca Scofield in a criminal case or investigation falls within the scope of legal representation and attorney immunity. They're not defending her because she's not a criminal defendant. But filing a frivolous federal civil complaint against a United States citizen that is exercising a federal right guaranteed by the United States Constitution, fabricating the allegations to conjure up a cause of action, conspiring to harass, demean, embarrass, publicly humiliate, and discredit a United States citizen that is exercising a federal right guaranteed by the United States Constitution, filing a frivolous civil complaint against a whistleblower in federal court to prevent your client from criminal investigations from law enforcement agencies. They're not suing you for being a whistleblower. Frankly, they don't care that you contacted the Idaho State Police or the FBI. They care about your TikToks. Your TikToks are not whistleblowing. Filing a frivolous complaint in federal civil court against a whistleblower to prevent your client from overall suspicion of murder is illegal, unethical, not within the legal scope of representation of the client, and not protected by an extreme remedy like absolute immunity. Absolute immunity is an extreme remedy, and it is justified only where any lesser degree of immunity could impair the judicial process itself, citing Lacey versus Maricopa County, 9th Circuit, 2012, en banc, quoting Kalina. What kind of, like, first off, it's not a conspiracy to represent a client. Like, if you're representing your client, like, so if a client comes to me and says, "Hey, Joe, I want to hire you as my attorney," and okay, he pays my retainer. I'm now his attorney, and he says, "All right, here's what I hired you for. I want to go out and rob a bank. Plan it with me." That makes me a co-conspirator. If my client didn't rob a bank, and the bank says, "Hey, Joe's client robbed us," and I say, "No," and now I'm going to sue, now my client is suing you for defamation, the bank, that's not me then conspiring. Helping to plan the bank robbery would be conspiring. Suing based on their false allegations is not conspiring. If without my help, my client did rob the bank and they hired me to defend them in the criminal case, or they hired me to defend them from the bank suing them in civil court for the bank robbery to recover the damages, the bank can't then say, hey, Joe is defending the bank robber, the alleged bank robber, trying to prevent us, the bank, from recovering our damages. Therefore, that means he's conspiring to help them get away with it. That would be ridiculous. The attorneys being hired after Professor Scofield was defamed to sue to recover damages for that defamation is not a conspiracy. It's a lawsuit. And like this Lacey versus Maricopa County. What is the absolute immunity claimed there? Let's see. Pulling it up on my phone just because it's going to be faster. And first off, it's a 1983 case concerning allegations of unlawful conduct by officials in the Maricopa County Sheriff's Office and the Maricopa County Attorney's Office, conduct which culminated in the late-night arrests of Michael Lacey and Jim Larkin, owners of the Phoenix New Times Inc. LLC. Lacey, Larkin, and the New Times sued Sheriff Joe Arpaio, head of the Maricopa County Sheriff's Office, County Attorney Andrew Thomas, head of the County Attorney's Office, former Independent Special Deputy Maricopa County Attorney Dennis Willenchick, and Maricopa County collectively defendants under numerous federal and state causes of action. The district court dismissed all federal claims and remanded all state law claims back to the Arizona courts. We affirm in part and reverse in part, finding that Lacey adequately alleged several causes of action for which the defendants are not entitled to immunity. We remand further or for further proceedings. So they arrested someone. If they fabricate this is a state actor, for starters. So absolute immunity for like prosecutors have a lot of immunity, but they can violate civil rights, and like they're not being sued for what is alleged in the case. I'm guessing. You heard everything I read from that case, but just from what I've seen, I think it's going to be very easily distinguishable. But the official seeking absolute immunity bears the burden of showing that such immunity is justified for the function in question, citing Burns versus Reed, Supreme Court, 1991, citing Forrester from the Supreme Court as well. Well, but that's the official seeking absolute immunity. The official seeking governmental immunity. That's different than a lawyer seeking litigation immunity. They're different immunities. It is not within the mission and functions of an attorney to commit criminal offenses like perjury. First off, it's not perjury because they are making allegations. They are not making sworn statements. They are not under oath. The attorneys have not committed perjury, period. They have not committed criminal offenses. It's not within the mission and functions of an attorney to commit criminal offenses like perjury by filing federal claims in federal court under false pretense and false allegations for the purpose of harassment and depriving a United States citizen of a constitutional right and property. Allowing immunity for illegal, perjurious filings allows for attorneys to commit fraud on behalf of their clients under the color of legal immunity. It also compromises the integrity of the judicial system. Response to the Kohberger argument. Now, this is nitpicking, I realize, and it's difficult when, you do have page limits. But she didn't adhere to the page limits in this filing anyway, which makes this especially egregious. And I let it go the first time, but she's got, like, it's bad enough if you leave the first sentence of a new paragraph hanging on the page. Just put the whole paragraph on the new page. But if you leave the heading for a new section as the last line on a page and then start that new section on the next page, stylistically, that is so aggravating. It's so hard to see. I know it's nitpicking, but don't do it. Like, if you can avoid it, just don't do it. If it's the only way you can fit within the page limits, see if you can cut other sentences out. Just try not to do this. That's not legal advice, that's writing advice. But responses to Kohberger argument. Counterclaimant Ashley Guillard has not claimed to be a party to Mr. Kohberger's case. The counter-defendant's argument is moot. But the only way that Section 1985 sub 2 works is if you are a party, a witness, or a juror in a case. The case in question is the University of Idaho murder case, where Mr. Kohberger is the defendant. So you have not claimed to be a party to Mr. Kohberger's case. Therefore, that doesn't make the counter-defendant's argument moot. Their argument is, you're not a party to the case. You're not a witness. You are a nothing to the Kohberger case. Therefore, 1985 sub 2 does not exist for you as a cause of action. It cannot. You being a party to Scofield versus Guillard, them suing you in Scofield versus Guillard it's not intimidation of you in Scofield versus Guillard for the purposes. It doesn't work. It can't work. It's a circular argument. So you saying you have not claimed to be a party to Mr. Kohberger's case That's an argument against yourself. It's an argument against yourself, Miss Guillard. It bolsters Professor Scofield's argument. Argument against the allegation that Ashley Guillard did not specify the right kind of harm. Because she hasn't. The pertinent aspect of 42 U.S.C. section 1985 sub 2 allows for a cause of action if two or more persons conspire for the purpose of impeding, hindering, obstructing, or defeating in any manner the due course of justice in any state or territory. The due course of justice, that would be the Kohberger case. But once again, it's I mean, she leaves so much my brain isn't working anymore because Ashley Guillard broke it. She's broken me. But she leaves so much out. If two or more persons in any state or territory conspire to deter by force, intimidation, or threat any party or witness in any court of the United States from attending such court or from testifying to any matter pending therein, freely, fully, and truthfully, or to injure such party or witness in his person or property on account of his having so attended or testified, or to influence the verdict, presentment, or indictment of any grand or petit jury in any such court, or to injure such juror in his person or property on account of any verdict, presentment, or indictment lawfully assented to by him, or of his being or having been such juror, or if two or more persons conspire for the purpose of impeding, hindering, obstructing, or defeating in any manner the due course of justice in any state or territory, with intent to deny any citizen the equal protection of laws, or to injure him or his property for lawfully enforcing or attempting to enforce the right of any person or class of persons to the equal protection of the laws. Now, I interpret this, the section she's doing, once again, the bottom, she ignores the part about intimidating a party, witness, or juror. I interpret this part as this would be Brian Kohberger's cause of action for causing Ashley Guillard to not testify. I could be reading that wrong, but that's how I interpret it. Who does not have a cause of action for that? Ashley Guillard, because Ashley Guillard, let me check my notes. Ashley Guillard is not Brian Kohberger. But the pertinent aspect of 1985 sub 2 allows for a cause of action if two or more persons conspire for the purpose of impeding, hindering, obstructing, or defeating in any manner the due course of justice in any state or territory. The counter-defendant's actions meet this requirement. The counter-defendants conspired for the purpose of impeding, hindering, obstructing, and defeating investigative efforts in the case of the murder of the 4 University of Idaho students, to avoid Rebecca Scofield from being investigated and charged with quadruple murder. Proper investigation of information and tips is part of the due course of justice in criminal proceedings. Your TikTok is not, though. They're suing you for your TikToks. Your TikToks have absolutely nothing to do with the proper investigation, quite aside from the applicability of Section 1985. Your TikTok is not the investigation by the Idaho State Police or the FBI. It's completely irrelevant to the case. They're suing you for TikTok, not for contacting the Idaho State Police. Proper investigation of information and tips is a part of the due course of justice in criminal proceedings. Counterclaimant Ashley Guillard emailed tips to the FBI tip line about Rebecca Scofield's motive and role in the murders. She also posted her findings about the details of the murder online. You're being sued for one of those, not the other. Rebecca Scofield and her attorneys conspired to hinder and impede the investigation of the information Ashley Guillard gave to the Moscow police, state police, and federal detectives by discrediting the legitimacy of Ashley Guillard and her information. That is not the behavior of an innocent professor who didn't know the students. It is the aggressive behavior of an overzealous serial killer who desires to get away with murder. If Rebecca Scofield was truly an innocent professor who didn't know the students, Ashley Guillard's tips and a criminal investigation wouldn't be a threat. You're being sued over your TikToks. If you didn't make the TikToks, Professor Scofield wouldn't know about the tips. I wouldn't know about the tips. The world wouldn't know about the tips. You're being sued over TikTok. The delusion is strong. The pertinent aspect of 42 U.S.C. Section 1985, sub 2, allows for a cause of action if two or more persons conspire with intent to deny any citizen the equal protection of the laws. But that's not it. It's with the intent to deny them the equal protection of the laws. But there's something before that. Like, even in the portion that I believe only applies to Koberger here, not to Guillard, if two or more persons, she completely skips over. She reads, if two or more persons conspire for the purpose of depriving her of her equal protection of laws. But no, she missed out this part. So if two or more persons conspire for the purpose of impeding, hindering, obstructing, or defeating in any manner the due course of justice in any state or territory with the intent to deny any citizen of equal protection of the laws. That's different. That's different than if two or more persons conspire with the intent to deny any citizen the equal protection of the laws. What this is just a misquote. And like, if it allows for a cause of action if ellipses, two or more persons. Where's the ellipses? Let's see. If two or more persons conspire for the purpose. So there needs to be an ellipses between conspire and with. If two or more persons conspire, ellipses, with the intent to deny any citizen the equal protection of laws. This is a misquote. This is dishonest. This is bad. This is a misquote of the law. She wants to talk about Rule 11 sanctions. Don't misquote the law. You can be sanctioned. I mean, it's like Seinfeld. You yada yada'd over the best part. Oh, I mentioned the bisque. She yada yada'd over an awful lot here, except she didn't even yada yada. She just skipped right over it, pretended it wasn't there. Putting an ellipses would be the yada yada. She didn't even do that. She pretended the lobster bisque was the only thing. To discredit Ashley Guillard and her information about the murder of the 4 University of Idaho students, the counter-defendants conspired to deprive Ashley Guillard of her right to free speech and the free exercise of her spiritual practice that's guaranteed by the First Amendment of the United States Constitution. The entire claim, Scofield versus Guillard case, is a falsehood. Ashley Guillard did not defame Rebecca Scofield. Her statements are substantially true and protected by the substantial truth doctrine. However, since the false allegations in the complaint was taken as true, as legally required, Ashley Guillard's right to free speech, an impartial tribunal, and her freedom to exercise her spiritual practice was threatened. The fabrications in the claim taken as true presented the claims in the false light. If the truth was told, the state law defamation claims would be dismissed due to no cause of action. Seriously? But so she's suing because Rule 8, the Iqbal and Twombly standards require Professor Scofield's plausible, non-conclusory statements in her complaint be taken as true for the purpose of the 12b6 motion to dismiss, which Ashley Guillard went straight to an answer. She didn't do a 12b6 motion to dismiss. So nothing has been accepted as true for any purpose by the court, because at best, Ashley Guillard has forfeited her 12b6. So by answering first, she can do a summary judgment motion, which is similar, but it goes on the undisputed facts, the agreed upon facts. So if the agreed upon facts presented by Ashley Guillard and Professor Scofield support a defamation cause of action, Professor Scofield wins on summary judgment. But she thinks, well, if the truth were told, if my truth were accepted in Professor Scofield's complaint, then the state law defamation claims would be dismissed due to no cause of action. But that doesn't create a cause of action for you in any universe. Because the state tort claims in the original complaint meet the elements of Idaho defamation law under false pretense, it positions the federal judicial system to allow for a cause of action in error, positioning Ashley Guillard to be deprived of Rule 12b6 of the Federal Rule of Civil Procedure Protection. You waived 12b6. You filed an answer. Fairness, due course of justice, and equal protection of the laws permits a dismissal of claims for failure of the complaint to state a claim. Your claims are going to be dismissed. It doesn't create a cause of action for you. I mean, even if you could go back in time and file a 12b6 before your answer were entered, and your 12b6 were granted, it doesn't give you a cause of action. You could maybe recover costs. It's not a cause of action. The pertinent aspect of 42 U.S.C. Section 1985 sub 2 allows for a cause of action if the party so injured or deprived is damaged and seeks the recovery of damages occasioned by such injury or deprivation against any one or more of the conspirators. Ashley Guillard's reputation was ruined. It allows for a cause of action if the party so injured is deprived. So injured or deprived is damaged and seeks the recovery of damages. So hang on. If the party was so injured or deprived of what? What were you deprived of? What were you injured by? What? Once again, I think this is a dishonest quotation. Like it's not just a bad interpretation. I think it's a dishonest interpretation of 1985 sub 2. And like reputation is not one of the damages imagined in section 1985 sub 2. Like the portion she's looking at, it's with the intent to deny for the purpose of impeding, hindering, obstructing, or defeating in any manner the due course of justice in any state or territory, with intent to deny any citizen the equal protection of laws, or to injure him or his property for lawfully enforcing or attempting to enforce the right of any person or class of persons to the equal protection of laws. Where does that say reputation? Or I'm just, I'm going insane. I'm going insane here. I'm going insane here. And I still have 12 pages to go. How? How do I still have 12 pages to go? How? I realize I've had a few tangents. I realize I've gone and looked at the law. How am I only on page 19 of 31? How? I need to speed through this because I'm going insane. And I'm running low on water. So Ashley Guillard's reputation was ruined. She lost business income. The integrity of her spiritual practices was debunked. I mean, didn't take a lot to debunk it. Telling her, no, I'm not the murderer. Well, yeah, it debunks her, but it's also not defamation. Her social media page on the TikTok application was permanently banned. She was routinely harassed. She's forced by law to spend time and resources to fight for her right to the freedom of speech. I prefer to fight for my right to party. Under the pressure of meeting deadlines, filing answers, and responses to frivolous pleadings, she was forced to spend less time with family, to include her cousin, Julius Marshall, who was in intensive care and subsequently died at Memorial Hermann Greater Heights Medical Rehabilitation Center in Houston, Texas, on February 19, 2023. Additionally, she's forced to use her own time, energy, and resources to prove she's telling the truth. Ergo, positioning her to do the job of Moscow, Idaho law enforcement without the resources. The ego on this one. The ego. If only the Moscow, Idaho law enforcement would do their job so I don't have to do it for them and get sued for the trouble. Ooh, I hate her. I realize that's a strong word, but it's true. For all the reasons above, Ashley Guillard disagrees with the counter-defendant's allegation that Ashley Guillard did not specify the right kind of harm. Fourth counterclaim for relief, 42 U.S. Code, Section 1986. Counterclaimant Ashley Guillard incorporates by reference once again, a bad citation. As quoted by the counter-defendants pursuant to 15 Amjur second edition Civil Rights, Section 183, to bring a claim under 42 U.S.C. Section 1986, it is necessary to show that an actionable claim existed under 42 U.S.C. Section 1985. The third counterclaim for relief meets the elements of 42 U.S.C. Section 1985. Therefore, the counter-defendant's argument for dismissal of 42 U.S.C. Section 1986 counterclaim for failure to state a claim under 42 U.S.C. Section 1985 is moot. Fifth counterclaim for relief, 42 U.S.C. Section 1983. Once again, a bad citation to the counter-complaint. Counter-defendants argue that Ashley Guillard's 42 U.S.C. Section 1983 claim, counterclaim 5, fails because she has not alleged any state action. I agree with Professor Scofield and her attorneys. Ashley Guillard, however, disagrees. The counter-defendants quoted Scott v. Thompson from the District of Idaho in 2020 in support of their assertion, which says, Section 1983 actions can be asserted only against state actors or, in very particular circumstances, against private actors acting under color of law. Suing is not acting under the color of state law. This would be, let's say, I falsely citizens arrested someone. That might, and based on a protected class, that might constitute state action for a 1983 civil rights claim. It's not guaranteed, but it could. There might be a few other, but it's very particular circumstances. She's just going to go with the delete laws. Nope defense, I bet you. She's not going to find one of those particular circumstances where it actually works. I haven't read it, but I'm guessing that's what's going to happen or not. The first pertinent aspect of 42 U.S. Code Section 1983 applies to every person under color of any statute, ordinance, regulation, custom, or usage of any state or territory. The plaintiff and counter-defendant, Rebecca Schofield, filed a frivolous Idaho state law civil defamation claim against Ashley Guillard in federal district court due to diversity of citizenship. She also claims to have filed a police report for defamation against Ashley Guillard. No. Where did she claim to have filed a police report for defamation? Which is ridiculous because it's a civil matter, it's not criminal. So why would she file a police report? The only place I recall Professor Schofield having any mention of police interaction was the police saying, yeah, you're not a suspect. We're not investigating you. She's making stuff up. She's making even more stuff up, I should specify. I'm losing my mind here. Pursuant to Idaho Code Section 18-4802, 2022, every person who willfully and with a malicious intent to injure another publishes or procures to be published any libel is punishable by fine not exceeding $5,000 or imprisonment in the county jail not exceeding 6 months, pursuant to Carver v. Ketchum from the Idaho Supreme Court and Clam v. Koppel from Idaho Supreme Court, I assume, Adair versus Freeman. To prove a claim of defamation, the plaintiff has the burden of proving each of the following elements. The defendant communicated information concerning the plaintiff to others. The information impugned the honesty, integrity, virtue, or reputation of the plaintiff, or exposed the plaintiff to public hatred, contempt, or ridicule. The information was false. The defendant knew it was false or reasonably should have known that it was false. The plaintiff suffered actual injury because of the defamation and the amount of damages suffered by the plaintiff. By filing a police report in the state of Idaho under false pretense and false allegations, Rebecca Schofield subjected Ashley Guillard to the color of Idaho Code Section 18-4802, 2022. By filing a frivolous civil complaint for libel through legal representation, Rebecca Schofield subjected Ashley Guillard to the color of case laws in the state of Idaho regarding libel. This is beyond ridiculous. Once again, I haven't seen anywhere. This really is the first time I remember seeing any mention of a complaint to the Idaho State Police. Now, the Idaho Police, to my knowledge, have not charged this Idaho Code Section 18-4802. Ashley Guillard hasn't been charged with it. She's not going to be either because, but this isn't under the color of law. It would be if the Idaho police arrested her for slander and the Supreme Court said, yeah, that was First Amendment. She can be punished civilly but not criminally. She could sue the Idaho police, the state of Idaho, for 1983 color of law false arrest, but not Professor Scofield. How am I not done with this yet? The second pertinent aspect of 42 U.S. Code Section 1983 is subjects or causes to be subjected any citizen of the United States to the deprivation of any rights, privileges, or immunities secured by the Constitution and laws. The counterclaim defendants subjected Ashley Guillard to the deprivation of the right to free speech guaranteed by the First Amendment of the United States Constitution. If only courts had already carved out the defamation exception to the First Amendment. If only defamation were an existing cause of action. Oh, it is? So alleging an existing cause of action that isn't precluded by the First Amendment, therefore, alleging that cause of action is not a violation of the First Amendment. And therefore, you don't have a cause of action. Even ignoring the procedural improprieties of saying, well, you subjected me to deprivation of my rights under the color of law by suing me, which isn't a thing because suing someone doesn't give rise to a cause of action. I mean, at least except in very, 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 very limited circumstances, which I'm not going to get into because it's not relevant here because by filing a frivolous claim in the U.S. District Court, knowing it was false and that it would by law be taken as true, except it's not because you didn't, that's only for the purpose of a 12b6 motion. You didn't file a 12b6 motion. So you keep harping on, well, by law, it would be taken as true. That's completely irrelevant because you never filed a 12b6 motion. The counter-defendants subjected Ashley Guillard to the deprivation of the right to a fair and impartial tribunal. Court is the fair and impartial tribunal. You can't. And it's like, well, because at the 12b6 motion, which I didn't do, for the purposes of the 12b6 motion, it has to be taken as true. Therefore, I don't have a fair and impartial tribunal, even though at all other stages of the litigation, it's got to be proven with evidence, giving me a fair and impartial tribunal. But because the 12b6 motion, which I didn't file, has this standard, the third pertinent aspect of 42 U.S. Code Section 1983 requires injury. Being unlawfully subjected for state laws or officials to deprive a constitutional right is injury enough. Is it? It's the state officials causing you. That's what it is. Ashley and this is just, once again, I call delete laws captain conclusory. I don't know if Ashley Guillard is lieutenant conclusory or if she's colonel conclusory. Is she a step above or a step below delete laws? Because, boy, she loves her conclusory statements, especially her conclusory statements on the law, which are wrong. Because being unlawfully subjected for state laws or officials to deprive a constitutional right is injury enough. That's conclusory. Would be nice to have a citation there. She's not going to find one, so the next best thing is a conclusory statement. Ashley Guillard also suffered other injuries: loss of income, damage to her reputation, a loss of current and potential customers and revenue, loss of time with family and friends, mental anguish due to harassment, and a loss of resources. Meeting all three fundamentals of 42 U.S.C. Section 1983 makes Professor Scofield and her attorneys liable to the party injured, Ashley Guillard, in an action at law, suit in equity, or other proper proceedings for redress. For that reason, claimant Ashley Guillard asks the court to deny the counter defendant's motion to dismiss the fifth counterclaim for relief. Sixth counterclaim for relief: malicious prosecution and frivolous claim. Counterclaimant Ashley Guillard makes another bad reference, bad citation. The counter defendants confer with Howard v. Felton. They confer with that's quite the conferral, speaking with the court from 1963. They refute the claim with Howard versus Felton. They're not conferring with anything. But they confer with Howard v. Felton from Idaho courts in 1963 that an action for malicious prosecution requires proof: 1, that there was a prosecution; 2, that it terminated in favor of plaintiff; 3, that the defendant was the prosecutor; 4, that the defendant was actuated by malice; 5, that there was want of probable cause; and 6, that damages were sustained. The counter-defendants seek dismissal of the sixth counterclaim because Professor Scofield's defamation claims against Guillard have not been terminated in Guillard's favor. Ashley Guillard disagrees. They haven't been, period. How can they be terminated in her favor? But yet she disagrees. Rule 18A of the Federal Rules of Civil Procedure. A party asserting a claim, counterclaim, cross-claim, or third-party claim may join as independent or alternative claims as many claims as it has against an opposing party. Okay. Rule 18B of the Federal Rule of Civil Procedure. A party may join two claims even though one of them is contingent on the disposition of the other, but the court may grant relief only in accordance with the party's relative substantive rights. But here's the problem. Here's the problem. Even just reading 18B, a party may join two claims even though one of them is contingent on the disposition of the other. That would mean you, Ashley Guillard, may bring two claims that are where one is contingent on the disposition of the other. And this isn't alternative pleading where you say, I think either this happened or this completely different thing that isn't compatible with the other, but one or the other happened. You can do that. That's called pleading in the alternative. But for this, it would be, let's say, this isn't a very good example, but bear with me. It would be bringing a false arrest claim and a 1983 claim. Civil rights. Now, if the false arrest claim is tossed out and they say, no, it was a proper arrest. It was a proper conviction. Go to jail. Well, then the civil rights claim is rightfully going to fail because it's not explicit, but in reality, it's contingent on the disposition of the false arrest claim. What this doesn't say is, well, you can bring a claim now that's contingent on the disposition of your opponent's claim. So basically, let's see if I can be more succinct. The false arrest or false prosecution that it was terminated in favor of the plaintiff for the malicious prosecution claim. That would be the defendant in the contingent, well, the defendant in the claim that this is contingent on. But that's not what is foreseen by 18B. That's not what it talks about as contingent, because the dismissed in favor of, or terminated in favor of the plaintiff here, that is a condition precedent. That means it has to have occurred before you can even bring suit. It's not a I am bringing two claims where one claim relies on the other not being dismissed or relies on the success of the other. Otherwise, this one fails too. That's what 18b is talking about here. So Rule 18b of FRCP, a party may join two claims even though one of them is contingent on the disposition of the other, but the court may grant relief only in accordance with the parties' relative substantive rights. A plaintiff may state a claim for money and a claim to set aside a conveyance that is fraudulent as to that plaintiff without first obtaining a judgment for the money. So yeah, that's irrelevant here. That's completely irrelevant. It doesn't need more explanation because it's irrelevant. Rule 18 of FRCP allows for counter-defendant Ashley Guillard's seventh counterclaim for malicious prosecution on the grounds of disposition of Rebecca Scofield's defamation claim. Except it's a condition precedent, and so you can't even bring the claim. It fails now because that element is not met now. The plaintiff's claims for defamation are likely to fail on the grounds that it fails to meet the elements of libel as required by Carver versus Ketchum and a whole host of other citations that I've already looked at. The plaintiff must prove that the alleged defamatory information was false, and the defendant knew it was false, or reasonably should have known that it was false. Defendant Ashley Guillard has an unbreakable faith in her spirit, spiritual acuity, and spiritual practice. She has strongly held that she believes that everything she said about Rebecca Scofield is substantially true, not once faltering despite circumstances. Knew it was false, or reasonably should have known it was false. That's a reasonable person standard. A reasonable person is not going to believe that fan fiction is true, that tarot card readings are true. She's terrible at this. I don't blame her. She's not an attorney, but she's terrible at this. She should have hired an attorney. But she's going with the delusion defense. Your Honor, I'm delusional, therefore I can't have defamed anyone. She has strongly held that she believes that everything she said about Rebecca Scofield is substantially true, not once faltering despite circumstances. For that reason, even if Rebecca Scofield is not criminally investigated or found guilty of the murder of the 4 University of Idaho students, her defamation claims does not meet the elements of defamation. The counter-defendant's tactic so far as to disprove spiritual practices, metaphysical practices, spiritual connection, the existence of a spirit in the human body, mediumship, psychic abilities as authentic or plausible. To meet the or reasonably should have known that it was false element required for a libel claim. But it's a reasonable person standard. But Their tactic is unconstitutional as it requires that an entire spiritual practice that is protected by Title VII of the Civil Rights Act of 1964 be determined as unreasonable by the court. They will not win this argument. They will. And now, imagine, if you will, if Professor Scofield used this exact same argument. Ashley Guillard's claims that I, Professor Scofield, defamed her fail because I believe that I did not murder anyone, and I believe that she is a charlatan. I believe that the tarot readings are quackery. I reasonably believe that. I reasonably believe that she is a charlatan. Well, she is going to win on that, but she's also going to win on the evidence because other than, well, the spirits told me being one side's only evidence, whereas the other side's evidence being evidence. For those reasons, counterclaimant Ashley Guillard's sixth counterclaim for relief for malicious prosecution should not be dismissed. Seventh counterclaim for relief, malicious prosecution, and frivolous claim. Once again, a bad citation. Counterclaimant Ashley Guillard realleges and incorporates by reference the response to the motion to dismiss the sixth counterclaim for relief on this document, pages 22 through 24. The counter-defendant seeks the dismissal of the seventh counterclaim for relief for the same reason as the sixth counterclaim for relief. For the reasons as stated above, Ashley Guillard disagrees. Counterclaimant Ashley Guillard's seventh counterclaim for relief for malicious prosecution should not be dismissed. Eighth counterclaim for relief, 42 U.S. Code, Section 1985. We've been over this before. Oh. Why? Another bad citation. The counter defendants used the same reasoning to request a motion to dismiss the third and eighth counterclaims. Counterclaimant Ashley Guillard realleges and incorporates by reference the response to the motion to dismiss the third counterclaim for relief on this document, pages 11 through 20. Additionally, the counter defendants add that Guillard has potential remedies: a motion to change venue, probing voir dire, a delay of trial, etc., which she has either opted not to pursue or could try to pursue in the future. Sitting on potential remedies does not give rise to a cause of action under 42 U.S.C. Section 1985, Sub 2. I agree, but Ashley Guillard disagrees. 42 U.S.C. Section 1985 does not require the party injured to self-remedy outside of the filing of a civil action the damages or injuries caused by the co-conspirators. Instead, 42 U.S.C. Section 1985 Sub 3 places the liability of damage remedy on any one or more of the conspirators that conspired against the person that was injured or deprived. And she keeps jumping between Section 2 and Section 3 of 1985. Though they're in the same statute, but they're separate causes of action. She needs to pick one. And, she's this is the one where she says, well, this is a deprivation of my civil rights under 1985, which it isn't, but because they brought the case in the wrong venue in Idaho instead of Texas. And that puts me at a disadvantage because I have to defend myself in the wrong jurisdiction, which, you know, the remedy was to change venue, which she did not do, at least not properly. But by filing counterclaims, she waived it entirely. Probing voir dire, because she argued, I'm at a disadvantage because I, a Texan, have to defend myself in front of an Idaho jury. Probing voir dire. You can ask the jurors questions. Yes. Dismissed. Simple as that. A delay of trial. Well, she's arguing, hey, you're making me defend myself. You can delay the trial. Ask for more time to prepare a defense. But no, it's a deprivation of her civil rights, even though it's not, even though she brought it under a completely ridiculous statute anyway. But ninth counterclaim for relief, 42 U.S. Code, Section 1986. Another ridiculous citation, as quoted by the counter defendants pursuant to 15 Anger, Second Civil Rights, Section 183, to bring a claim under 42 U.S.C. Section 1986, it is necessary to show that an actionable claim existed under 42 U.S.C. Section 1985. The eighth counterclaim for relief meets the elements of 42 U.S.C. Section 1985. Therefore, the counter defendant's argument for dismissal of the 42 U.S.C. Section 1986 counterclaim for failure to state a claim under 42 U.S.C. Section 1985 is moot. 10th counterclaim for relief, intentional infliction of emotional distress. Once again, I'll parrot the defense's argument. Suing for defamation is not outrageous. It does not inflict extreme emotional distress. Therefore, it is not intentional infliction of emotional distress. The counter defendants argue for the dismissal of the 10th counterclaim, intentional infliction of emotional distress, because they claim the defamation action is not extreme or outrageous. Counterclaim and Ashley Guillard disagrees. The counter defendants confer to a state of Becker versus Callahan, State of Idaho, 2004, for the four elements of intentional infliction of emotional distress. Four elements are necessary to establish a claim of intentional infliction of emotional distress. 1, the conduct must be emotional or reckless. 2, the conduct must be extreme and outrageous. 3, there must be a causal connection between the wrongful conduct and the emotional distress. And 4, the emotional distress must be severe. The 10th counterclaim for intentional infliction of emotional distress meets the extreme element. To understand this, it is vital to include every fact that could in any way be relevant to give the court as complete a picture as possible. Don't give every fact possible. Jesus Christ. Bring case law. Bring case law that shows what is extreme and outrageous. Filing a lawsuit is not extreme and outrageous. It isn't. It can't be. Otherwise, once again, you'd have unending circular litigation because I sue you. Therefore, you sue me for intentional infliction of emotional distress. I sue you for intentional infliction of emotional distress. You bring a new claim against me for it. And then I bring a new claim against you. And on and on and on ad infinitum. It can't work that way. Rebecca Schofield, these are the facts according to Guillard, Rebecca Schofield had an inappropriate affair that Professor Scofield initiated with University of Idaho student Kaylee Gonsalves. The lesbian relationship was hidden due to Rebecca Schofield being married, perceived to be heterosexual, and a professor at the college Kaylee Gonsalves attended, University of Idaho. When the relationship faltered and broke up, Rebecca Schofield feared that her secret affair with a woman and student would cause damage to her marriage, reputation in Moscow, Idaho, and the University of Idaho, and career at the University of Idaho. She also feared Kaylee Gonsalves moved on to be with another woman, one of her friends. For those reasons, Rebecca Schofield planned, initiated, and hired men to murder Kaylee Gonsalves and her friends. On November 13th and 14th, 2022, the plan was executed. As a result, the four students were brutally murdered. Well, I agree that's extreme conduct, if it were true, which it's not. It's what's the causal connection? Remember, one of the elements, there has to be a causal connection between one and the other. Like, if Kaylee Gonsalves were Ashley Guillard's sister and Ashley Guillard witnessed the murders, hey, there you go. That's extreme conduct that's directly tied with a causal connection. But for random people you don't know being murdered somewhere that you are not by someone you also don't know, how does that have anything to do with you? How does that cause you the legal tort of intentional infliction of emotional distress? It doesn't. Rebecca Schofield was getting away with murder. The investigators initially had no known suspects. No suspects known to you. No suspects known to you. That doesn't mean they didn't have suspects. The push to solve the case heightened. Ashley Guillard was asked by a TikTok user to use her spiritual practice to get details about the murder of the four students and the murderer. Using her spiritual practice, Ashley Guillard discovered the motive, murderer, and two male co-conspirators. Has she named them? They ought to sue if she has. She discovered that Rebecca Schofield ordered the murder of four students. She posted her findings on TikTok as requested and sent the information to the FBI tip line. To evade suspicion, obstruct justice, and to avoid criminal investigation, Rebecca Schofield, with the help of her attorneys, executed a strategy to discredit, embarrass, defame, humiliate, harass, silence, and destroy Ashley Guillard and her spiritual practice. When it comes to destroying her spiritual practice, I can only say good. To accomplish this, they conspired to deprive Ashley Guillard of the First Amendment right to freedom of speech, of the right to an impartial tribunal, of the First Amendment right to the free exercise of her spiritual practice, and of approximately $2 million by filing a frivolous defamation claim with malicious intent and falsified allegations under the color of law. The counter-defendants do not argue against the other three elements of an intentional infliction of emotional distress claim. Arguing against one is enough. If they could have argued against all four, but if they successfully argue against one, they win. They win because you have to successfully allege all four. They just have to poke a hole in one. They refute that the counter-defendant's conduct does not amount to extreme and outrageous. And once again, they only argued against that element in the motion to dismiss. That doesn't mean they have conceded to the other elements. They can still argue if it's not dismissed. They can still argue in their answer. They can still argue at trial against each and every element. But they only have to win on that one element to get the motion to dismiss granted. And frankly, it's not extreme and outrageous because filing a lawsuit against someone is not extreme and outrageous conduct as contemplated by intentional infliction of emotional distress. However, that's exactly what the counter-defendant's conduct is: illegal, extreme, outrageous, and unnecessary. If counter-defendant Professor Scofield was innocent and had no connection to the students, the criminal investigation process would not be a threat, nor would Ashley Guillard's statements. She feared an investigation and was angry about being minimally exposed by Ashley Guillard. 100 TikToks calling her a murderer is not minimally exposed. She caused 4 students to be murdered to protect her own self-interests. She then sought to destroy Ashley Guillard under the color of law and by harassment to protect her own self-interests. For these reasons, the 10th counterclaim for relief for intentional infliction of emotional distress should not be dismissed. This is the Chewbacca defense. Look, a shiny Wookiee. Or what is it? Look at the funny monkey. Look at the funny monkey as he dances. Doesn't make sense. But she's claiming that the murders that she's accusing Professor Scofield of committing, she's saying the murders were extreme and outrageous. Therefore, I haven't suffered from intentional infliction of emotional distress. That's not how that tort works. That's so far from the mark that I mean that this entire argument was wasted because, like, Professor Scofield's argument was A. Ashley Guillard's argument was Twinkie. It's a different universe. 11th and finally, counterclaim for relief: intentional infliction of emotional distress, press releases, and statements. So the 10th counterclaim was generic intentional infliction of emotional distress. But this one is for press releases and statements. Another bad citation. The counter defendants used the same reason to move to dismiss both claims for intentional infliction of emotional distress. 10th and 11th counterclaim. Counterclaimant Ashley Guillard realleges and incorporates by reference the response to the motion to dismiss the 10th counterclaim for relief on this document, pages 25 through 27. Her argument is the press releases and statements caused me intentional infliction of emotional distress, is her cause of action, alleged. But I'm re-alleging the previous section, meaning she did the murders, therefore the press statements caused me intentional infliction of emotional distress because they were outrageous. Because the murders were outrageous, the press statements count as intentional infliction of emotional distress. That doesn't work. That's arguing A, and she's arguing ding dong. I don't know why I'm sticking with Hostess confectionaries when I don't like either of them. And now we're on to the argument against the request for the court to exercise its inherent power to award Professor Scofield her attorney's fees. The counter-defendant's request for the court to exercise its inherent power to award Professor Scofield her attorney's fees because they allege Guillard's conduct throughout this case shows a clear desire to delay the proceedings, to ignore reasonable requests from Professor Scofield's attorneys to cease and desist defaming Professor Scofield, and to increase the litigation costs for Professor Scofield. The allegations about Ashley Guillard are false. The counter-defendants confer. No conferring. That's not how you use the word confer. They rely on Mark Industries Ltd. versus Sea Captain's Choice Inc. From the Ninth Circuit in 1995, which says, the court has the inherent power to correct such bad faith misconduct. The district court had discretion to discipline Bertram pursuant to its inherent powers for willful abuse of the judicial process or bad faith conduct. Ashley Guillard has not operated in bad faith or misconduct. Defending herself against a frivolous complaint and asserting counter-complaints is within her right as a United States citizen. Exercising federal rights is not misconduct or bad faith. So Professor Scofield suing you for defamation, well, that's grounds for a lawsuit. That's grounds for a lawsuit. You bringing completely frivolous counter complaints is your right as an American citizen, and exercising such right is not misconduct or bad faith. How does that not apply to Professor Scofield suing you? Oh, well, it's because one's against you and one's for you. Would you like to have your cake and eat it too? Defendant and counterclaimant Ashley Guillard has not desired to, nor does she intend to delay the proceedings. Then why didn't you respond on time? Why was your answer late? Why were you in default? The issue of the 30-day late answer has been resolved by the court. But it also involved extra attorney's fees. At the very least, that should be compensated. Ashley Guillard has not knowingly or intentionally filed any late pleadings, responses, or motions since then. She is doing the best she can as a pro se litigant to stand her ground against the frivolous, malicious, and fraudulent claims. Defendant Ashley Guillard did not ignore Attorney Olson's cease and desist letters. She denied ceasing communication about Rebecca Scofield because she believes Scofield to be a serial killer. Ashley Guillard is telling the truth, ergo is protected by the substantial truth doctrine and the broad parameters of the First Amendment of the United States Constitution. Defendant Ashley Guillard does not know if and how much Rebecca Scofield has paid for a group of 3 attorneys. It was Rebecca Scofield's decision to hire 3 attorneys. The plaintiff and her attorneys decided to file a frivolous complaint against Ashley Guillard that does not meet the elements for libel as required by Carver versus Ketchum. It is only the initial phases of the litigation process. Perhaps costs should have been discussed before filing the fraudulent claim. If the plaintiff and counter-defendant cannot afford legal fees, there are remedies like dropping the case. or a GoFundMe. Please, Professor Schofield, do a GoFundMe. Your fees will be covered. I'll make sure that Emily Baker discusses such GoFundMe if you ever do. She has no self-awareness here. If Professor Schofield can't afford, well, she can just drop the case. Well, if Ashley Guillard didn't want to be sued, she could have stopped at the first or even the second cease and desist. She's in the find out phase of the F around and find out. Rule 41, sub 2 of the Federal Rules of Civil provided in Rule 41A1, an action may be dismissed at the plaintiff's request only by a court order on terms that the court considers proper. If a defendant has pleaded a counterclaim before being served with the plaintiff's motion to dismiss, the action may be dismissed over the defendant's objection only if the counterclaim can remain pending for independent adjudication. Unless the order states otherwise, a dismissal under this paragraph 2 is without prejudice. I'm having shades back to November with delete laws. Ashley Guillard decided to litigate her own defense and counterclaims. She has not intended to increase the cost of litigation for Rebecca Schofield, nor for herself. She is simply standing her ground within the parameters of the law. For these reasons, and for the reasons stated in this entire response, Ashley Guillard requests the court to deny the counter-defendant's request for attorney's fees. Conclusion. Counterclaimant Ashley Guillard requests that the court deny the counterclaimant's entire motion to dismiss and deny the request to award Professor Schofield her attorney's fees. Dated June 27th, 2023. Signed, Ashley J. Guillard. It's over. It's finally over. It's finally over. I'm free. I've been given a sock. I'm free. Luckily, I only need one sock. I'm free. That was garbage. That was complete and utter nonsense. And now, are you ready for some delete laws? I'm not. Oh, I thought I'd get through that a lot faster than I did. But, like, I knew 31 pages, that's a long motion. I didn't think it would take me 4 hours to get through that nonsense. But here we are. So with that, I'm not getting to delete laws today. But like I said, happy Canada Day to those of you north of the border. And apparently it's also Territory Day, I think, in the Northern Territory of Australia and the British Virgin Islands. So happy Territory Day to those of you there. If I don't know if I have any viewers there, but if you are, say hi. But with that, hopefully I won't be so busy. I mean, other than the obvious holiday this coming week, I don't foresee this being nearly as busy as the last 2 weeks. Hopefully I'll get to delete laws this weekend, if not early next week. But do like, share, subscribe, and like I said, if there's a shorter than a minute clip that you think would be a good short, give me a timestamp, start and end timestamp, ideally. Leave that as a comment, and yeah, other than that, thanks for joining me. I'm going to get out of here. Bye-bye.